welcome to Alexa's room, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people who have opinions about all things going on in the true crime community, including what the heck is going on with the Ashley Benefield case. Now, if you are new to this case, a very quick synopsis. Ashley Benefield is a former Florida ballerina who has been charged with second-degree murder for fatally shooting her late husband, Douglas Benefield, in an act of which she claims is self-defense. Now, whether or not the defense can prove it was self-defense, or rather, whether or not the prosecution can prove it wasn't out of self-defense and that there was some intent behind this act, we will see in real time. The prosecution has already rested their case, but in Alexa's room time, we are a couple of days behind, so we are going to catch up with the day 2 recap. If you missed my video from yesterday and you're still catching up on this case, highly recommend you check out my day 1 recap as well as opening statements. Those are 2 separate videos, which I will link in the description below. First, we went through creepy cousin Tommy Benefield's testimony, and I feel pretty confident saying he's creepy because, I don't know, some of those text exchanges were a little creepy deep to me, gave me creepy uncle vibes, but that's just my opinion. We went through his testimony first, then we went through Eva Benefield, the daughter of the victim, Douglas Benefield, her testimony, as well as a potential violation of her subpoena, since she has been sequestered under subpoena as a potential rebuttal witness for the state, whether or not she actually violated it from posting some stuff on TikTok and also speaking with a reporter. We went through that. We also went through the 911 call that was placed by the next door neighbor of Ashley Benefield and Alicia Beyers, her mother, John Sant. And then we finished things off with the crime scene tech testimony, which just pretty much walked us through, what they stumbled upon when they got to Ashley Benefield's house, the evidence that was bagged and tagged, how it was bagged and tagged, which is very refreshing. If you have been following the Karen Reed case, the chain of custody was a little bit more tight there in Manatee County. And then also some of the photos that she had taken a few days later to see if there was any bruising that had been showing on Ashley Benefield's body. So that was all in day 1. Again, I'll link that in the description below. But today I want to get into day 2 because there's a lot of freaking testimony, guys. We got Stephanie Murphy, the attorney of Douglas Benefield, during the knockout. I think she describes it as a knockout, drag-out custody battle between Douglas and Ashley, as well as the potential soon. I think he was also going to use her as a divorce attorney as well too. She's a family court attorney. Well, she took up the majority of this day, so that will be the bulk of this video. We'll also get into Detective Gilliam's testimony as well too, the lead detective on this case, and how things may have been potentially handled, as well as what other as well as Dr. Broder's testimony. He was the one who ultimately filed that report that the prosecution is alleging the reason why Ashley had fatally shot Douglas Benefield 3 days before the hearing where this report was allegedly supposed to come into play. I really want you guys to pay attention, put your little armchair detective hats on, take notes if you need to, because a lot of what is testified in day 2 will come up in future / present world, whereas in Alexa's room world, we're working in rewinds. So just pay attention, especially to Stephanie Murphy's testimony, because there are potential areas where she could be potentially perjuring herself, which we will come to find out in later videos as a quick little spoiler. Okay, that being said, let's dive in. I want to kick things off with Alicia Beyers' testimony. Again, she is the mother of Ashley Benefield. Not a whole lot that came out of this testimony. It was pretty short and sweet, but just confirming again a little bit about Doug and Ashley's relationship. You'll also see the prosecution trying to extract some information of how well versed in firearms Ashley was, and if she was going to the range before this incident took place to, I guess, prepare herself for the shooting. So we'll get into this, and let me know if you think this testimony helps or hurts the state. I don't want to give too much away, but personally, I feel like I'm not really sure why the state called her as a witness, other than to maybe pull one over the defense's head and say, "Ha, we called her first." I don't know, but that's just my opinion. Let me know what you guys think in the description below, and let's let it rip.
Good morning, ma'am. My name is Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Scoot up just a little bit. We need to get you about 12 to 15 inches from that microphone. It does adjust up, down, left, right as you need it. If you speak in a loud, clear voice right into it, it'll pick up everything.
Thank you.
Yes, ma'am.
Good morning. Please state your name.
Alicia Beyers.
Can you spell your first name and last name, please?
Alicia Beyers.
And your relationship to Ashley Benefield.
She's my daughter.
And when did she start living with you in Florida?
I can't clearly remember.
Okay. Was there a time when Ashley moved in with you when she was pregnant?
Yes.
Okay. And she was married at the time, but it was just Ashley that moved in.
Yeah, he brought her down.
Okay.
And yes, and yeah.
And she moved in with you.
Yeah. He told me I needed to take care of her. He dropped her off.
Okay. So she.
And I know I have this at 1.5 speed, so things are a little bit faster, but I'll rewind really quickly. And again, listen to what she says. She says, yeah, he brought her down here, meaning Douglas or Doug. He brings her down here and he says, according to the mother, you need to take care of her. Because again, remember, a few things. Ashley's pregnant, had a really rough pregnancy from what has been previously testified to. She also suffers from fibromyalgia, which could be another reason why this is even more of a difficult pregnancy for her. So I just want you to, I'm going to replay that so you can hear that again, but just keep note of that too, because everything that the prosecution is asking is done intentionally and has to go along with whatever narrative that they set forth during opening statements. And from what I can recall in opening statements, they want to believe that, okay, Ashley was pretty much like, Doug, I'm moving down to Florida. You know, you can't help me out. I'm moving in with my mom. I need her to take care of me, and I don't want anything to do with you. And like just completely cutting him off. Like, take me down there, drop me off. I need my mom. That's kind of the angle that the prosecution is going with. Whereas from at least what Ashley's mom, now you can say she's her mom, she could be biased, which is fair. But according to the mother, she's saying, no, he dropped her off and he said, you need to take care of her. Because the pregnancy must have been so difficult that he probably didn't know how to help her. And again, I'm just from the perspective of the mother, this is what it sounds like. You need to take care of her because I don't know how to, and I don't want to deal with this. That's the impression I'm getting from this testimony. But let me know what you guys think in the comments section below.
If you speak in a loud, clear voice right into it, it'll pick up.
First name and last name, please.
Alicia Beyers.
And your relationship to Ashley Benefield.
She's my daughter.
And when did she start living with you in Florida?
I can't clearly remember.
Okay. Was there a time when Ashley moved in with you when she was pregnant?
Yes.
Okay. And she was married at the time, but it was just Ashley that moved in.
Yeah, he brought her down.
Okay.
And yes, and yeah.
And she moved in with you.
Yeah. He told me I needed to take care of her. He dropped her off.
Okay. So she stayed with
I mean, does that sound like a loving, caring husband? Again, this is just testimony, perspective from the mother. So obviously she's going to be biased towards her daughter. It's her daughter. But from the way she makes it sound like, he dropped her down there. He didn't want anything to do with her. Okay.
you from that time on, correct?
Yes.
Okay. And does Ashley have a concealed weapons permit?
Yes.
Does she own firearms?
She doesn't now, no.
Did she own firearms then?
Yes.
Okay. How many?
Two, I think. Yeah, two.
Did she ever go to the firing range or anything?
Yes.
I'm sorry.
Yes.
Okay. How frequently would she go?
Well, we did all the courses to get the concealed carry, and I don't remember.
Okay. And very shortly before the shooting, she went to the shooting range with your neighbor, correct, John Santz?
I don't think that was close to that time, no.
So it may not have been close in time, but they have gone together? Ashley and John Sands?
I'm not sure.
Okay.
I don't know.
So that's another key thing too, because again, the prosecution needs to prove that there was some sort of intent, which is why I think it's important to play a little bit of this testimony, because I feel like it doesn't really help the state in terms of their timeline of events. Because if they're saying, well, she was going to the range, she was practicing, trying to, make sure that, she hit her target, right? Going to the range with the next door neighbor who ultimately made the 911 call, which is also interesting. But the mother here is like, I mean, one, I don't know, but no, if she did go to the range, it wasn't like right before. Maybe it was like a couple weeks before, but it wasn't like she was going like leading up to this event. So also interesting.
Okay. Um, and you and your daughter obviously are very close. You lived together, just the two of you, right, for a while.
Mhm.
And then once the baby was born, the baby lived there with you.
Correct.
Correct. Okay. And around that time of the shooting, were you planning to move to Maryland?
Yes.
And you had a house that you inherited in Maryland?
It was the house I grew up in.
Okay. And you inherited that house?
Yes.
So your plan was to move to Maryland with Ashley and Emerson, the baby?
Mhm.
Okay. And Doug, Ashley's husband, was also moving to Maryland?
He was moving somewhere else. He was, yeah.
Okay.
He had found his dream job.
So he was moving to Maryland, but not moving into your same house?
Correct.
Okay. And he was packing up to move at the same time you were?
I assume so, yeah.
But he was coming over to help
Yes.
you move?
Yes.
And on a regular basis, almost every day, he was at your house?
Maybe the last week.
Okay.
Yes.
Helping move boxes and things like that?
Yes.
And you all rented a U-Haul, right?
Somebody rented a U-Haul. I don't know who.
It was in your driveway, though, correct?
No, it was not my driveway.
The day that shooting happened, was it in your driveway?
I think
If you don't know,
the
that's
U-Haul was getting there when I was leaving.
So again, what she's confirming is, and this is what the prosecution wants to say, is, well, they rented the U-Haul together. And from the way that this testimony is going and the way that I'm interpreting it, and again, she's the mother, she knows as much as she knows. She's obviously close with her daughter. I don't know how much or how little Ashley actually disclosed to her mother, but it seems like her mother was in kind of the know and hadn't obviously had enough of an idea as to what was happening, at least from just an outsider perspective of what might have been going on between Ashley and Doug. But from the way I'm seeing it is, she's like, I didn't rent the U-Haul. Somebody did. It was probably Doug. It's probably Doug, if I'm going to put my speculation hat on. And why were they sharing a U-Haul? That's what I want to know. Probably because if you want to, again, if you're in line with the defense's theory of she did this out of self-defense, she's a DV victim, that could have been a manipulation tactic, a way to control the situation, make sure, well, I'm going to pack my boxes with your boxes so that we have to ride together. We have to ultimately, our stuff is together, it's mixed in together, so you're stuck with me. He's following her to Maryland. A lot of red flags, in my opinion. But again, this is just based on the mother's testimony. Let me know what you guys think in the comment section below.
You also had a pod for
Correct.
those?
That was in my driveway.
In your driveway, okay. On the date of the shooting, what time did Doug get to your house? Do you remember?
No, I mean, it was, I can guess, maybe like 5 or something. I don't know.
So it was still light out?
Oh, yeah.
And maybe in the afternoon sometime?
Yeah, I don't clearly know.
Okay. So when he showed up, what did you do? Did you stay there or leave?
I was leaving when he pulled up.
And where did you go?
We went to the park.
Okay. When you say we, who is we?
Oh, Emerson and I.
Okay.
Yes.
So just you and Emerson. And
Yes.
how old was she at the time?
So I guess 2, maybe. Yeah.
Approximately.
Yeah.
And at the house, was it just Doug and Ashley then?
Yes.
When you left?
Mhm.
And you've obviously been in contact with your daughter almost every day since the shooting, correct?
Leading. No rule.
You've been in contact with her basically every day, correct?
Not
Since
initially, no.
for the last several years, you've been in contact with her every day.
Well, yeah.
Okay. And
no, okay, yeah.
did she ever?
I mean, like, probably when they were living together, obviously, they'd be in contact every day, I would assume. You're living in the same house. But I don't know if you guys are catching on to this, but what the prosecution is ultimately trying to say is Ashley told her mom, take Emerson out of the house, go for a walk. Let me be alone with Doug. Like, this is part of some kind of, I guess, master plan. to prove, to go along that there was some sort of intent.
During any of these conversations tell you what happened when she had to shoot Doug?
Never.
When you came back from the park, I'm assuming she was already in the squad car or she was already with law enforcement?
I have no idea where she was.
I'll sustain.
So at the time that the shooting happened, she didn't tell you what happened?
No,
Correct.
we've never talked about it.
And to this day, you've never talked about it?
No.
Thank you. No further questions.
So they never talked about this incident. She's going to say a couple of interesting things during cross-examination. But what do you think? Do you think that helps the state's case? I don't think they do anything on redirect for this witness. But what they want to do establish is that, yes, Ashley and Doug were there alone. Did Ashley gear up for this a few days beforehand by going to the range? She denied that. Okay. So she wasn't going to the range a few days before or leading up to this event. Okay. Scratch that. But she did try to get you out of the house. But she was saying, well, no, we just, we went for a walk. Doug was pulling up as we were leaving. Could this have been a coincidence or was it intentionally done by Ashley? Let me know what you guys think. So now we're going to get into cross. And again, this is really short testimony, but I think it's important because it just establishes some of the timeline of just the series of events of when Doug arrived there. I also think the bit about the U-Haul was interesting. And I didn't catch this actually initially when I was listening back on this testimony, but she didn't know who rented the U-Haul. She knew where the pod was. Okay, so that may have been something that she had rented, but she didn't know who rented the U-Haul. One can only speculate that if, again, you are to believe that Ashley did this out of self-defense, that could have been a manipulation tactic by Doug as a way to control her and make sure that, hey, your boxes are with my boxes, and I'm going to make sure that you get to where you say you're going, and I know exactly where you're heading to. So let's go to cross.
Good morning, Ms. Beyers.
Morning.
Are you nervous?
Yes, very.
Scared?
Yeah.
All right. Let's try to relax. If my questions aren't clear, please just ask me to repeat it.
Okay. Thank you.
Was there ever a time when you and Ashley resided here in Bradenton, in the home, that Doug lived in that house?
Never.
Never lived in that house. Which I think also might have been
Would it be
misreported
safe to assume
in the
that
media as
perhaps
well
you can
too.
enlighten us a little bit? How was your relationship with your granddaughter, Emerson?
Oh, very good. Yes, we're very close.
And would you try to spend time with her?
Yes.
Would that include you taking her somewhere on a regular type basis?
Yeah.
Would that be to the park?
Yes.
And tell the ladies and gentlemen of the jury, Ms. Beyers, how often you engaged in that practice of you and Emerson going to the park?
Usually several times a week. And we go after it cooled down because the park is not a very good, tree coverage. So it was very hot. That was the only comfortable time to go.
So we think.
Which I completely understand too, because my wife and I actually used to more so my wife, she would nanny for our niece. Granted, she was a newborn, but several walks a day, not just a week, but several walks a day. And obviously at this point, Ashley's daughter was a little bit older. So I think she was about 2 when this happened. But it makes sense. You would go out when it's cooler. I know that there were a couple of times where it was like extremely hot or extremely cold out, and trying to gauge the best times to take the baby out, also to try and get the baby to go to sleep. So this isn't like unusual for me. And I'm sure any of you guys who, 1, have children, or 2, have a niece or nephew that you've babysat before, this would make sense. So I feel like this is a good strategy by the defense in kind of debunking the theory of, well, it's unusual behavior for the grandma to be taking the child to the park on this particular day. Well, no, it seems like this was a routine thing. She was close. Obviously, Ashley lived there with her. She was there during her pregnancy, so she would actually have a close bond with her granddaughter. She seems to be taking her several times to the park, going for walks. So I feel like that's pretty believable to me.
Think trying to avoid the heat or
Oh, yeah.
minimize it, it'd be later in the afternoon.
Yeah, it was
Near
brutal out there, it
Florida.
was. Florida,
So I
yeah.
can only
Almost as
imagine.
bad as it is now.
Right, exactly.
Um, how far away was the park?
It's a short walk. I mean, we'd always walk over there. So I don't know, take us maybe 5 minutes to get there.
Okay.
So
And on this particular day, I think you told Miss O'Donnell, if I'm not mistaken, you were actually in the process of going with Emerson to the park when Doug arrived.
yes, we're walking down the driveway. I had her in the stroller.
And on this particular occasion, there was nothing unusual about you going to the park, just
Oh,
like
no.
you
No,
did
that's when-
regularly.
yes.
Give me a moment, Your Honor, please.
We're going to skip ahead a little bit. He's going to discuss that. I think his name, I think the paralegal's name, ironically, is Mr. O'Keefe. But there's a lot of like similar names there's like a Dr. Russell in this case as well too, where there was a Dr. Russell in the Karen Reed case. There's also like other things that kind of weirdly mirror the Karen Reed case, even though they're completely different cases. But let me know if you guys pick up on any of the similarities.
I believe that's all I have, Your Honor. Thank you, Ms.
You're
Okay.
correct.
No.
Hold on, man, don't get up yet. No,
No.
Can this witness be released?
Yes.
Yes.
Ma'am, you're released from your subpoena. The rule of sequestration had been invoked, but you're now
Okay,
released.
so she's released from her subpoena. She's not going to get recalled as a rebuttal witness by the state or by anybody. So she's all free to go. But I think that established a couple of really important points in terms of just debunking kind of where the prosecution's theory was going of, is this unusual behavior for grandma to be taking the baby for a walk? No. I mean, could it have been coincidental from just the timing of it all? Yeah. So you could really spin it either way. But in terms of them trying to like, we gotcha in terms of Ashley going to the shooting range before this event, seems like they debunked Alicia Beyers debunked that herself without the defense needing to. So okay, I think she was pretty credible, but let me know what you guys think. So now we're gonna skip actually past the next two witnesses. So they did call Dr. Russell. She was the clinical psychologist that Ashley actually lived with, which is just weird. There's so many boundary lines that are being crossed throughout, like from professionals in this case. I can't believe it. And for me, like I've had my own personal experiences with professionals crossing boundary lines, including my own therapist. So that was a little bizarre testimony. Not really helpful. I honestly, in terms of like credibility and showing her bias, I could definitely see that. I mean, she lived with Ashley. I don't know why. But I don't think it's really important. Then we heard some testimony from Lieutenant Daniel Dickerman, which was, again, confirming just a lot of what we already heard from day one's recap. So I want to get into Stephanie Murphy's testimony because this is going to take up the bulk of probably this video, but it also took up the bulk of day two's trial. There's a lot that comes out. We're probably going to go through the entire testimony just because there's so much. And then we're going to get into Detective Gilliam's testimony, Dr. Broder, and then I believe Dr. Quintel as well too.
Hello, ma'am. My name is Judge White. I'm going to be presiding over the case.
And again, she is the attorney. She was the attorney for Douglas Benefield during the knockout dragout, as she describes it, custody battle between Ashley and Douglas.
Please get yourself about 12 to 15 inches from the microphone. It does adjust up, down, left, right. Just make yourself comfortable. If you speak directly into the microphone with a loud, clear voice, we'll hear everything.
Thank you.
Thank you.
Good morning.
Good morning.
Please state your name.
Stephanie Murphy.
How do you spell first and last name?
Stephanie is Stephanie. Murphy is Murphy.
And what is your profession?
I'm an attorney.
How long have you been an attorney?
This is my 23rd year.
I'm an accountant. I don't know. It's just what that reminded me of, if you guys know that TikTok.
As an attorney in the Sarasota Bradenton area.
And are you with a firm, sole practitioner? What do you do?
My husband and I have our own firm, and I've had that firm for 16 and a half, 17 years. Before that, I was at a larger firm in Sarasota.
And what is your topic of law that you practice?
I practice family law, which is generally comprised of divorce, custody cases, or what used to be called custody cases, and adoption cases.
Okay. I want to ask you about Doug Benefield. Did he hire you?
He did.
And approximately when did he hire you?
He hired me in March 2018. He came for a first consultation on the 13th. He hired me on the 14th of March 2018.
And what was the purpose of your duties to begin with?
Initially, the purpose of hiring me was to draft a letter to Ashley Benefield, who was pregnant with their child at the time, which I did. I drafted a letter and sent it the day after I was retained. But the purpose of that letter was actually just to initiate.
Relevance. She stated that she sent a letter, that she was retained to send a letter, but now going to explain something.
Okay, overruled.
What was the purpose of the letter?
The purpose of the letter was to open the door for discussion about Doug's participation in the upcoming birth of their child, but also to advise that if she did not feel comfortable with him being present at the birth, he was respecting her need for space.
So again, remember at this point, Ashley is living in Florida because she was struggling with her pregnancy. She moved in with her mom. Doug was still in South Carolina. So this is why I believe he was still in South Carolina. And he retained, I guess, a Florida lawyer, which would probably make sense considering that Ashley is based in Florida and maybe he was planning on moving down there as well too. So it's kind of hard to. Doug seems to pop up in pretty much anywhere Ashley is. So in terms of timeline and when he appeared in certain places and when he didn't, it's a little hard to keep track of. But that's essentially what I'm gathering from here in terms of timeline of events.
And when did you send that letter?
I sent that letter on March 15th at 9:59 in the morning by email to Ms. Benefield.
9:59. I mean, you can tell she's been looking through all of this stuff in preparation because nobody can remember the exact time and date of when they send an email. Oh my God, I'm like thinking about my own email box and I'm just like already having already getting anxious and overwhelmed. But just to quickly recap, Doug retained her. He wanted to be part of the birthing process. When Ashley was ready to give birth, Ashley actually gave birth prematurely, which we kind of find out why she may have given birth a little bit prematurely later on, probably in tomorrow's recap. But she was hired by Doug a day later after she was retained. She sends this letter/email to Ashley, just trying to open the discussion for Doug being involved in the birthing process for their daughter.
And did you receive a response to that letter?
I did not receive a response directly from Ms. Benefield. She checked herself into Tampa General the next day to start induction.
Sustained.
So when was the child born?
Well, the child was born early. She was born on March 19th, I believe, is when she was finally born.
And you said early. How many weeks early was that?
Well, the child was originally scheduled, or her due date was April 8th. So I think
Sustained.
So you said you never received a response
not from Ms. Benefield.
from Ms. Benefield about the letter.
Correct.
And to your knowledge, did Doug ever receive a response?
To my knowledge, he did not receive any response from Ms. Benefield or anyone on her behalf.
Which I mean would make sense because if you are to believe that what Ashley's saying is true about being afraid of Doug, moving to Florida, trying to get as far away from him as possible, like, yeah, she's going to ignore him, probably not respond to him, probably didn't know what to do when she got this random email from, not random, but this email from his attorney, which I also find weird too. My lawyer friends, like, is this standard procedure to send a letter like this via email, or is that a little strange to you? I feel like something like this, that it's a serious matter, should be a little bit more official. Something sent by like certified mail. I don't know. That's just me, but is this standard procedure? Does anybody know? Does anybody else think that's weird?
And I think you might have said this, but the child was born on what day?
She was born on the 19th of March.
Okay. And at the time the child was born, did you or Doug know that the child was born?
No, gosh, we didn't know for a good 5 or 6 weeks after she was born.
Okay. And how?
And like, so this is where her personality, like, really, or like her thoughts and feelings towards Ashley start to really come out. Is, gosh, no, she makes a lot of comments like this that just make me feel a little icky and uncomfortable too, because and she constantly refers to Mr. Benefield, or Douglas Benefield, as Doug Benefield or as Doug instead of Mr. Benefield, which is also a little bizarre too, because one, he's your client. I mean, I call my clients by their first name, but if I'm talking to them or addressing them in a professional setting, I'm not going to call them by their first name, unless we're cool like that. But I'm also in marketing, so I feel like the rules are a little bit different. But I feel like in trial, when you're testifying in court, like it would be a little bit more professional to refer to the victim, your client, your former client, by his name, Mr. Benefield, instead of Doug. That's just my opinion. But she makes a lot of comments like this of, "Oh no, we didn't know that the baby was born. Like, I can't believe this happened. Gosh, no, I can't. Can you believe this? I can't believe this." What a wicked woman. It's just like, why are you so emotional about it?
How did you find out that the child was born?
I actually found out because I had been monitoring the docket for Manatee County court system, just because there had been no response. And so on May 6th, I saw that Ms. Benefield had filed a petition for protection against domestic violence on, I think it was April 23rd. So about 2 weeks prior to me finding out, she had filed the petition. And in that filing, there was, she identified the birth date of the child, as well as I think the child's name, which is the first time we learned about that too.
Okay. And you said she filed a petition for, what did you call it?
It's a petition for protection against domestic violence. So it's an injunction. A lot of people refer to it as a restraining order, but it wasn't granted as an injunction at the time.
Okay. So when, just for knowledge of,
Yeah, so that was the one in Florida, and remember, Ashley had one in South Carolina that was granted, but that the state of Florida didn't recognize for whatever reason. So it's interesting. So Ashley had the baby, didn't tell Doug. Again, that aligns with her narrative of feeling like she was in danger for her life. She was trying to ice him out. But again, it could also go along with the prosecution's theory of, well, she was just trying to take everything away from him. But I feel like, why would somebody do that if they're also trying to be a gold digger and digging for money? I don't know. I don't know. You guys let me know what you think. But what are your initial thoughts about Stephanie Murphy? I know we're a little bit early in her testimony, but she just gives like jealous ex-girlfriend, or like the girl who is always just friend zoned energy, and just no matter what she did, she could just never get the guy that she wanted, and he always just chose somebody else. That is the energy I get from her. Very Jim McCabe vibes.
to people that may not know, when someone does a request for an injunction, what is sort of the procedure that it needs to go through?
So a person who files a petition for an injunction, they file it at the courthouse in the clerk's office, and then that gets sent out to the judge, usually a family law judge who's just in charge of injunctions that day. And then the judge has 3 options, I believe. One is just to deny it completely.
Also, I know I keep stopping and going. I'm sorry about that, guys. I'm going to let her roll in a second. But I also wonder why she didn't follow up. Like, again, is that also standard procedure to not follow up? Again, just in my brain, I feel like if you send an email, like, I don't know what kind of relationship Ashley has to her email inbox, but I know mine has like over 10,000 unread messages. And if you send me an email, it's probably getting lost and buried somewhere, unless I like organize it a certain way. I can find it. If you send me an email, you tell me you sent an email, I'll go digging for it and I will find it. But also, too, if Ashley's trying to avoid Doug, she's probably, and who knows, maybe he already she's ignoring his text messages. Maybe he's calling her. She's ignoring it. Maybe he tries to email her, and she just doesn't check her inbox anymore. So it would be easy and fair to say that maybe she just didn't see it. It's possible, right? Totally plausible. Or maybe she did, and maybe she intentionally ignored it so she could figure out what she wanted to do, her next steps from there. But I find it interesting that you didn't send any follow-up to that first letter. I feel like, wouldn't that be kind of the next step, is if you don't get a response, wouldn't you send, like, after a certain amount of days, a certain period, wouldn't you just send, hey, here's a follow-up? Can we open this discussion? I don't know.
Completely. The second option is to grant a temporary injunction, but then there's a follow-up or a return hearing.
I'll overrule.
And then the third option is what happened in this particular case, is that the judge denied the petition as a temporary injunction. So there wasn't enough evidence in the petition to warrant a temporary injunction, but a hearing was set to review it.
Okay. And when was that hearing set approximately to your knowledge?
I believe it was originally set for May 8th, but Ms. Benefield made a request to continue that hearing.
Okay, so it was then continued?
It was.
Before the hearing actually happened, did you file any documents on Doug's behalf?
I did. So, well, of course, I filed a notice of appearance in that injunction case. And then we started an entirely separate case. So I filed on Doug's behalf a petition for a parenting plan unconnected with divorce. So he wanted to establish a parenting plan so that he had really time sharing and decision making for his daughter, because he had none of that to that point because she was withholding all that information.
And some of the lingo may be familiar to us, but so time sharing, what is that?
I'm sorry. So time sharing is what lay people and a lot of people used to generally call visitation. So it used to have custody, parent had custody, and then another parent had visitation. That was changed. And now in Florida, at least, and especially in our circuit, we have parenting plans, which is a comprehensive agreement or an order by the court that lays out all the details of parenting as a not intact family. So the major components are decision-making and time sharing schedule. So how often the child spends with each parent.
And you said not connected with a divorce proceeding?
Right.
So I would assume that means it can either be with a divorce proceeding or without.
It can be. And of course, it can be also in a paternity case. So parents don't have to be married. But in this case, because they were married, Doug was not initially pursuing a divorce because he hadn't had any contact with Ms. Benefield for a while. His initial,
Was sustained.
So initially it was not connected with divorce.
right, his priority was his daughter.
And you mentioned the injunction case and then your motions. Were they
Which is interesting too. So they're saying his priority was his daughter. Could that have been a potential boy? Okay, you're not answering me. Maybe this is the best way to go about it to get your attention, is to go through our daughter. I could definitely see that.
two different case numbers?
They were two different case numbers. So the injunction case number was 2018 DR 1823. And then the new case that I filed for Doug was 2018 DR 2318. Now they're companion cases though, so they might be separate cases, but they travel together as companion cases and they're assigned to the same judge through this unified family court program.
So when the hearing was set and
I just want to back that up a little bit, just because there's a lot of information to sift through. And like I said, I want you guys to pay attention to her testimony because it will come up later on in later testimony from Faith Brown, who was the attorney for Ashley Benefield, about some of these dates, about some of the contents of these hearings. So I think it's important for us to just get everything kind of
DR 1823. And then the new case that I filed for Doug was 2018 DR 2318. Now they're companion cases though, so they might be separate cases, but they travel together as companion cases and they're assigned to the same judge through this unified family court program.
So when the hearing was set and ultimately heard, were both of those case numbers heard?
Both of the case numbers were heard, but it wasn't our first pleading wasn't the same pleading that was heard at the time of the injunction.
Objection. It's narrative, non-responsive to the question.
Sustained.
So what generally were the allegations in the injunction petition?
Generally, Ms. Benefield was alleging that Doug had been violent toward her. She alleged that he had hit the dog, fired a gun into the ceiling. The biggest allegation was that he was poisoning her and their child in utero with heavy metals.
Okay. When was this?
So notice how she says alleging. Like none of these things were confirmed, but from previous testimony, we know, and we'll actually find this out too from future testimony, that yes, in fact, and even the pretrial hearings, I think with creepy Tommy Benefield, because he is a creep. Mr. Taylor nailed that one right on the head. He did punch the dog to unconsciousness, and he admitted it. That did happen. That's not alleged. That did happen. He did throw their 13-year-old cat. Now, whether or not he was attempting to poison Ashley, that's a different story, although there are reports that do come into play later on that may say something different. Whether or not it was alleged or not, that actually came into play in today's trial, day 4. So I don't want to jump too far ahead, but again, just to keep your eyes and ears open of what to pay attention to if it comes up later on.
Was heard at the time of the injunction.
Objection. It's narrative, non-responsive to the question.
Sustained.
So what generally were the allegations in the injunction petition?
Generally, Ms. Benefield was alleging that
restraining order.
Doug had been violent toward her. She alleged that he had hit the dog, fired a gun into the ceiling.
Which he did.
The biggest allegation was that he was poisoning her and their child in utero with heavy metals.
Okay. When was this hearing finally held?
The hearing was held in 2 parts, actually. It was July 30th, and then the second part was September 17th.
Not responsive to the question, Your Honor.
Overruled.
And that was the year 2018, correct?
Yes, it was.
Okay. And what judge was this in front of?
It was in front of Diana Moreland.
Okay. And you said it was held on 2 days. Why was it held on 2 different days?
It took a very long time. So both sides had experts, toxicologists, and we had a number of other witnesses appearing. We had,
Objection. Not responsive to the question.
Overruled.
there were also people from the child protective team testifying.
No, it's like she keeps shaking her head, and I don't know if the jury can see this necessarily because like they're on the other side and they're only getting a side profile, but like how the prosecutor keeps shaking her head, like I can't believe like you're objecting to this. Like I don't like this prosecutor. I don't like, and I'm just gonna be straight up. I don't like this prosecutor. I don't like her line of questioning. I feel like she's kind of a bully. But again, that comes in later into play on day 4's testimony, and you'll see why I think so. But I don't know. I feel like some of her conduct, while the defense constantly gets verbally slapped for making certain comments that might be, unprofessional. I mean, the prosecution shaking their head, showing some kind of emotion, I feel like that's kind of inappropriate conduct. My opinion.
And so there were too many hours, and so we couldn't squeeze it all into one day.
And ultimately, at the end of this, did Judge Moreland make a decision?
At the end of that, she did. There were
I'm
other
sorry.
decisions along the way, but ultimately she made a decision on the 2 matters that were set as the companion cases.
And what I meant was on the second hearing day, did she make a decision?
Yes, she
Okay.
did. September 17th.
And what was that decision?
There were 2 parts because, there was 2 cases.
Objection, Your Honor, just final decision.
For the prior motion?
Yes.
Yeah. Overruled.
Go ahead.
Thank you. For the injunction, she made a lot of rulings and a lot of findings about lack of evidence and then
But
denied
we don't
the
want to
petitioners.
talk about
Oh.
what went into that. We just want to know what her ruling was.
Okay, she denied the injunction. So
Okay.
that was the first
girl.
part.
Okay. And then the
You
second
know,
part.
you're an
The second
attorney.
part was on the parenting plan case, the time sharing case. And so in that, she entered a ruling for a time sharing schedule. That would be an introduction schedule because Doug at that point had never met his daughter, and that would increase over time on a temporary basis. And then she entered a ruling that he would have ultimate decision-making authority over the child's medical needs and otherwise share decision-making.
Overruled.
And otherwise, I'm sorry.
Otherwise share parental responsibility, which is joint decision-making.
And as of that day,
I want to go back to
Couple
that.
needs and otherwise share decision-making.
and then the second part.
The second part was on the parenting plan case, the time sharing case. And so in that, she entered a ruling for a time sharing schedule. That would be an introduction schedule because Doug at that point had never met his daughter, and that would increase over time on a temporary basis. And then she entered a ruling that he would have ultimate decision-making authority over the child's medical needs and
So he would have ultimate. What is the word that she says?
he entered a ruling that he would have ultimate decision-making authority.
Ultimate decision-making authority over the child's medical, like anything related to medical, which is very interesting because if he's just, and again, this is just my brain and how it works and how I'm hearing information, but if he's never met this kid before and she's saying, hey, I have a restraining order in South Carolina and I would like to do the same thing in Florida for X, Y, and Z reasons. Exhibit A, him punching a dog. Exhibit B, throwing the cat. Exhibit C, shooting a firearm into the ceiling and allegedly poisoning me. But even just taking that out of play, even with those 3 things, and you're going to give him ultimate decision making over this child who he hasn't met yet. I just feel like that's a little interesting.
Authority over the child's medical needs and otherwise share decision-making.
Overruled.
And otherwise, I'm sorry.
Otherwise share parental responsibility, which is joint decision-making.
And as of that day, was Judge Moreland's ruling timed? Like, was it immediate? Was it in the future for the time sharing?
It was immediate. Well, not that day, but she said the first day, and it was just a couple of days later, the 21st, which is when Doug was supposed to meet his daughter for the first time.
And this time that Doug met his daughter for the first time, were you present?
I was, yes.
And where did this happen?
It happened at Manatee County Sheriff's Department on, I think it's 301.
Did you arrive together or separate with Doug?
Oh, we arrived separately. When I got there, Doug was already there.
And how
So they arrived separately. Okay. Then what?
old approximately was the baby at the time?
I think she was around 6 months old. She was born in March, and this was then the 21st of September. It's about 6 months.
And can you explain how that interaction went? Did you observe it, first of all?
I did.
Okay,
So when I arrived, I got into Doug's truck, and we just waited because we were there early. And then
What? One, why are you there for the first time? Like, you, girlfriend, you did your job. Unless it was at Doug's request that his attorney be present, I guess, in case that Ashley didn't show up or she didn't follow the ruling that the judge had set. But I feel like, and I want to rewind again as to the location that they met at, but just like notice like that weird uncomfortable smile of her just smiling. Yes, we met this baby. Like it almost like it's like she's stepmommy and she's meeting like her new stepdaughter. It just a little bizarre and uncomfortable for me. Maybe I'm over exaggerating that, but I feel like boundary lines maybe so much. And I feel like if Doug really needed his attorney after the fact because hey, Ashley didn't show up, what do I need to do? You can always give her a phone call. But that's what's even weirder is the fact that you arrive separately, but then you jump into his car while you're waiting. Like that's a little weird. Don't you have other things to do, other clients? Take care of phone calls. Oh yeah, you have a husband too, right, girl? It's just a little weird. At times she gives the impression to me, like again, she's that girl who is just like she'll do anything for that guy that she's just so in love with who never gives her like the time of day, or like if he does, he's just kind of stringing her along because she's been completely friend zoned. That is the energy I get from this woman. And it's very uncomfortable. So again, I just want to backtrack a little bit, see where they met up. Because again, if it's at a mutual location, I believe it might have even been the police department.
the time sharing case. And so in that, she entered a ruling for a time sharing schedule. That would be an introduction schedule because Doug at that point had never met his daughter, and that would increase over time on a temporary basis. And then she entered a ruling that he would have ultimate decision-making authority over the child's medical needs and otherwise shared decision-making.
Overruled.
And otherwise, I'm sorry.
Otherwise shared parental responsibility, which is joint decision-making.
And as of that
I'm
day,
curious why
was
that
Judge
was.
Moreland's ruling timed? Like, was it immediate? Was it in the future for the time sharing?
It was immediate. Well, not that day, but she said the first day, and it was just a couple of days later, the 21st, which is when Doug was supposed to meet his daughter for the first time.
And this time that Doug met his daughter for the first time, were you present?
I was, yes.
And where did this happen?
It happened at Manatee County Sheriff's Department on, I think it's 301.
So it happened at the sheriff's department. I mean, like, if Ashley was a no-show with the kid, like, you're in the best place for that to happen, to say, hey, you know, my wife / soon to be potentially ex-wife was supposed to meet me here. She didn't meet me here. She's in violation of this order. What's your recommendation? What should I do from here? Like, you're in the perfect spot. If I'm Doug Benefield, I'm in the perfect spot at the Manatee Sheriff's County's department. Like, why do you need your attorney there? Ashley didn't show up with her attorney, did she? So I just find it a little bit bizarre. Like, you're trying to insert yourself into just like this very intimate moment of when this man is meeting his child for the first time. And like, you already did your job. You already got paid. So like, why are you there, girl? Why are you so attached?
Did you arrive together or separate with Doug?
Oh, we arrived separately. When I got there, Doug was already there.
Oh, we arrived separate.
And how old approximately was the baby at the time?
I think she was around 6 months old. She was born in March, and this was then the 21st of September. It's about 6 months.
And can you explain how that interaction went? Did you observe it, first of all?
I did.
Okay,
So when I arrived, I got into Doug's truck, and we just waited because we were there early. And then he saw Ashley arrive with the baby. And so he pulled the truck closer, and then we both got out of the car and started walking toward Ashley. And then it was just an odd kind of interaction, actually. She turned to me with this nasty look on her face and said to Doug,
I'll sustain this to the characterization.
she turned to Doug and said, "Are you dating her?" And so obviously we both said, "Of course not, no." And then I hung back and
Excuse me, what? Excuse me, what? There are so many things wrong with what she just said that are so inappropriate. And again, it reminds me of my own personal experiences. So quick story. I had a therapist, my very first therapist, who grew to be like a little too I guess, like, I don't want to say like obsessed, but like a little too just attached to me. And I was attached to her in a lot of ways because I was going through just a lot of my personal trauma experiences, which had a lot of the things that are discussed in this case. Um, but whenever it came to me talking about my fiance, now wife, or even the one or two interactions that my wife had with her, just like very briefly, very similar vibes. Not that she made a direct comment to my wife or to me about it, but there was definitely a vibe that just felt very uncomfortable and reeks of this. So again, I want to play this back. It's like, how, like, it's just you're his attorney. You're his attorney. Like you know what you're saying. You know you're on the stand. You know you need to be careful about what you say because you're on the stand. Everything is being documented and recorded, and you're injecting your own personal feelings towards the defendant, which you know is a big no-no. It's just weird. Like, why are you so emotionally invested? And not to say like you don't care about your clients. Of course. Like, in the case of my therapist, yeah, I want my therapist to care about me and to because I want them to help me. I'm paying them to help me. And in that case, Doug is paying her to help him, and she did. He got what he wanted. He got time sharing with Ashley. He got to meet his baby for the first time. Like, if he needs you again because Ashley's in violation of anything, he'll hit you up. Like, you're good. He'll hit you up if he needs you again. But why are you there? And why are you like, like you just like the hair whip of course not. Like, why would you think we're dating? Like, why do we make a good couple? It's just so odd and uncomfortable. It's like, girl, you're mad. Aren't you married? Didn't you just say you share a practice with your husband? Like, what did he think about this? God, it's just, and I know it's not relevant to the case necessarily, and I'm glad the judge sustained it because, like, yeah, like you're injecting your own observations and emotional response to a situation that you shouldn't be should be very like, hey, this is what happened, this is what we did. You shouldn't be injecting any of that. And it's just ugh, just makes her so unlikable and kind of creepy.
And Doug then was standing there, and Ashley approached him with Emerson, and they started talking. Eventually, she let him hold the baby, and they just kept talking for a few minutes. Then I was advised that they were going to be leaving together, strangely, that Ashley was going to be going with them for the time sharing.
Was this a surprise to you?
Absolutely. We had just been in knockdown, drag out litigation for months with just horrendous allegations that were unfounded. And yet she said, I want to go with you. And he said, okay.
Allegations that were unfounded, but they weren't unfounded. If you're talking about the poisoning, there was, and again, just kind of foreshadowing, there was an investigation done there. They actually called in today and day 4. I know, spoiler alert. We will get there. We will get to all of that as I'm like whipping my hair in my face. I'm just so excited because like there's so much about this witness that just reeked of just inappropriateness that I'm so happy the defense was able to call her out on some of her bull crap on day 4. But that being said, there was an investigation actually conducted by a prosecutor who actually believed Ashley, believed that she could have been potentially been poisoned, but had left before the investigation or before she could actually bring forth, I think, file charges and actually go forth with a trial in regards to it. So, unfounded on what? And also, too, it's not your position right now to testify to any of that. Like, no, you were just there to state facts. You're there to say, this is when we filed this. This is what we filed for. This is the result. This was what the ruling was. This is what happened. Doug met Ashley. Doug left with Ashley, and that's it. You're not supposed to be, oh, like, I just can't believe, like, after all of this, like, you're so emotionally invested in this. And I get if that's how you feel personally, like, keep that inside. Like, that's so. Why would you testify that? And like, especially, you're being filmed. So, like, why would you? And this is a great face. I might actually use this, guys. I might actually use this as part of the thumbnail. I'm not gonna lie, because this is a pretty great face. I just don't like this woman at all. She just gives mean girl energy, very Jen McCabe vibes. Sullivan
Objection to the
sisters.
Characterization of the allegations being unfounded and continued editorializing by this witness.
Yep.
Sustained.
Oh, and now they're gonna approach because the prosecutor, like, why can't she talk about how much she doesn't like Ashley? Because it's not relevant. Like the jury doesn't need to hear that. That's not what she's there for. And you can tell, like, look at this look. Like, she just does not like Ashley. And she's like, I can't believe she gave me a nasty look. And like, of course she's gonna give you a nasty look. One, she's afraid of Doug. According to Ashley, she's afraid of Doug. She doesn't want to be there. And she's wondering, who the heck are you? Because, yeah, at the time they're still married. And she probably still, I think a lot of people forget this too with DV relationships, is just because you're afraid of somebody and you feel trapped, it doesn't mean that you lose feelings for them. You know, she might be still in this conflicted state of, I love him. And like right now, it's really like this is an intimate moment between the three of us. And maybe we can make, like, there's probably so many things swirling in her brain just because you went through all of these court proceedings and you went through all these litigations. That doesn't matter. That doesn't mean that that's reflectant of what's going on in here. I can't tell you how many relationships I personally, and I've never been in court going in knockout, drag out litigation over custody. I've never had to experience that, so I don't know what that's like. And I've only heard it's just absolutely awful for most people. But again, I want to play this back a little bit because just the level of inappropriateness. And she knows what she's doing. It's not like this is just some like layperson who doesn't know the law and like what she like how she needs to be wording certain things in court. Like, she knows what she's doing. So like, why are you making yourself look really bad and really thirsty, in my opinion?
Talking. Eventually, she let him hold the baby, and they just kept talking for a few minutes. Then I was advised that they were going to be leaving together, strangely, that Ashley was going to be going with them for the time sharing.
Was this a surprise to you?
Absolutely. We had just been in knockdown, drag out litigation for months with just horrendous allegations that were unfounded. And yet she said, I want to go with you. And he said, okay.
Objection to the characterization of the allegations being unfounded and continued editorializing by this witness.
Sustained.
Like, I don't understand what the prosecution's problem with that is, because they do the same thing. They object to the same exact thing with every single witness that the defense crosses, but whatever. But again, but why is that so strange that they would leave together? And like, never once, again, I want to point out that she never once acknowledges and says, yeah, Ashley came and rolled up with her own attorney. Like, nobody else rolled up with their own attorney. They showed up at the county sheriff's department. Like, there was no reason probably for you to be there unless Doug requested it, which he probably did. Yeah, who knows? Who knows what the characterization of your relationship was between you and your client? We can only speculate. But I don't think it's that weird that Ashley would go along with Doug and that Doug would want Ashley to go along with him, because that's what he wanted all along. He wanted to be with Ashley. Allegedly, he wanted to be with his daughter. He wanted to be with his family. And they're still married at this point. They're not separated. They're not divorced. They're living separate lives, but they're not legally separated and they're not divorced. And they're sharing this intimate moment for the first time. He's holding the baby. Again, Ashley might be feeling a lot of conflicted feelings about the situation. Maybe she thinks, okay, maybe things will be different. As we learned today, that it takes people who are victims of DV and DV relationships up to 8 times before they actually leave the final time. And it makes sense to me that she would say yeah. And also too, if she's afraid for her own personal safety, she's probably afraid for the safety of her daughter. Hence all of this knockout, drag out litigation that she just went to court for months for, is to protect her daughter. So yeah, she's not going to just let him hang out with her daughter for the first time alone. She's going to want to be a part of it. And I'm sure Doug probably insisted, yeah, let's go together. That would be great. That's what he wanted. And now you just sound like a thirsty, jealous girlfriend, girl. Like, ugh. So they're going to sidebar. She smiles at the jury a lot, which is creepy. Uncomfortable. Very Jen McCabe. Very Jen McCabe vibes.
So when they told you they were going together, what was your response?
I pulled Doug aside and I cautioned him about going with her. I'm his attorney, and so I did advise him. I said, this isn't a good idea. She's trying to set you up for something. Don't do this. And he said, I understand. I'm going to go ahead and do it anyway. And so I stayed and observed as Ashley strapped the car seat into the back of the truck, and she got in the truck with Doug, and then they left together for his first time sharing with his baby, for their baby.
With his like there's the language she uses during her testimony is just so fascinating to me, because again, she constantly refers to her client by his first name, Doug. Okay. She gets into his truck while they're waiting for Ashley, likely to send some kind of message. You testified that you showed up separately, so why are you chilling in his car? I'm pretty sure you could be doing other things while you're waiting. So yeah, you know what? I'll meet you when she gets here. Yeah, we'll go in. We'll, or we can go into the sheriff's county's department and just chill inside. Why do you got to get in his car? That's a little weird. And I want to play that back again too, because again, it just goes to show just how emotionally invested she is, which is just extremely inappropriate in my brain. Extremely inappropriate in my brain. Just at least how she's the language and the words she's using. It was his baby. Oh, their baby, right? She doesn't even want to acknowledge Ashley. Like, Ashley is this awful, aggressive. Like, she's the one. She's the aggressor in the situation. Meanwhile, there's been no allegations against Ashley and Ashley showing any violent tendencies. This is all Doug. This is all Doug. So it's really fascinating to me. And obviously, she's going to be biased as her client, right? They obviously had some kind of close relationship. But the fact that you're sharing, I think don't do this. The fact that you're sharing client privileged information, conversations between you and your client, just because please, tell me if I'm wrong. Like, maybe there's a certain law around it where, hey, if your client is now no longer alive, you can testify to some of that client privileged information in a court of law. I don't know how that works. My lawyer friends, let me know. But I feel like this is privileged information. And if you're saying too, again, because it goes with the bias of the prosecutions, it goes along with the prosecution's narrative of, if you don't do this, I advised him, don't do this, she's going to set you up for something. Like, that for me is so telling of this witness, where her bias lands. She obviously had, and again, this is my speculation brain, but it feels like she had some, almost like a high school crush on Doug. Like, she just felt some kind of possessiveness over her. And maybe he also used some manipulation tactics over her as well too. Who knows? He seemed like a very charming guy. That's kind of the narrative that seems to be, that seems to have come up a lot in testimony. He was a really charming guy. He really knew how to talk people into giving him money to invest in all these different projects. So maybe he did the same thing too, even with his attorney, which is just absolutely fascinating to me. Just the certain word choice she uses, but I just feel really icky. Aren't you supposed to keep that information, what you say to your clients? Instead of just making the simple observation, they advised me they were leaving together. They left together and I went home. That's all you need to say. You don't need to give all this additional commentary of what happened, what you felt, because nobody cares. It doesn't matter. It's not relevant. We don't need to know what you think, Stephanie.
Response.
I pulled Doug aside and I cautioned him about going with her. I advised, I'm his attorney, and so I did advise him. I said, this isn't a good idea. She's trying to set you up for something. Don't do this. And he said, I understand. I'm going to go ahead and do it anyway. And so I stayed and observed as Ashley strapped the car seat into the back of the truck, and she got in the truck with Doug, and then they left together for his first time sharing with his baby, for their baby.
So mad about
after
it.
this first time sharing, did this seem to start a time of peace, so to speak?
It was a time of peace. Actually, before the 26th, but on the 26th, Doug and Ashley both signed a stipulation that I had drafted at Doug's request, which expanded the time sharing that Judge Moreland had ordered at the hearing on the 17th. So within a week, they had already agreed that he was going to have even more time sharing than Judge Moreland had said.
Okay.
And so that was filed in the court file. It took away the restriction of meeting at the sheriff's office if they chose.
Non-responsive.
Overruled.
So yes, that was the beginning of a time of peace that extended for quite a period of time.
And during this time, well, how long did that last, the peace?
It lasted, to my knowledge, about 11 months.
Okay. And during this 11 months, did you see Doug and Ashley?
I saw them in magazines. Actually, they were attending gala events together. And so they were kind of
Speculative and hearsay.
Overruled.
so other than seeing them together at the sheriff's office, I didn't personally observe them out in public, but I did. Like I said, I saw them in various forms of media. They're quite the couple.
And
I love her characterization. And look how like Ashley's not even looking at this woman because one, she was like, who the heck are you? I guess they never like met each other. I guess everything was done without the two being present because I also found that interesting that when Doug showed up with his attorney, according to Stephanie Murphy, if you want to call her a credible witness, her showing up to the sheriff county's department and Ashley not knowing who she was and thinking, oh, was this like a girl, like your new girlfriend, yada, yada, yada. I also find that interesting as well, too. Like, she didn't even know who you were. But yeah, she seems definitely mad that or like disappointed that they made peace, which I get, like, in a way, if you go through this whole extensive thing and you feel, I guess, a personal attachment to the case that you're working on, the project, the client, you feel for them, you empathize with them. I'm not saying that that's a wrong thing. You might be a little bit disappointed that things didn't shake out the way that you think. You know, again, we want the people we hire obviously to care about us, but not like to the point where, I don't know, I feel like there are some boundary lines for sure being crossed, but there was peace being made. She says that she saw they were quite the power couple and she saw them in magazines for about 11 months. It seems like this peace had been made between Ashley and Doug. And again, a lot of people might speculate, well, you know, if she was really a DV victim, why would she be making peace? Like, why would she? I could see it going both ways where people would be like, oh, it's Ashley stringing Doug along. She's dangling the baby, you know, to try and keep him in her life. But for whatever reason, I mean, again, we established he has no money and she's probably aware of that. Like, he has no money. So why would she continue to just dangle, like string him along? I'm just not seeing that motive. But if you guys see something that I don't, please comment in the comment section below. That's what it's there for. Just keep it respectful, please. But we can always agree to disagree. But I can see it definitely for sure from the perspective of Ashley, if she is a DV victim, which it seems like, in my opinion, it seems pretty legitimate to me that she would want to try and make things work out. And she would say, okay, well, we're stuck in this situation. We're stuck co-parenting. So yeah, I am going to make the peace. And again, she probably has these conflicting feelings of, well, he's being really nice to me now. Maybe he's different. Maybe now that we have a baby, and again, her getting pregnant when she did, maybe she thought that would solve a lot of their problems. We have a baby. How many times have we heard that? People get married because they think it's going to solve a problem. People buy a house because they think it's going to solve a problem. People have a baby because they think it's going to solve their relationship problems, and it doesn't. So I can definitely understand her saying, okay, I'm stuck in this situation. I don't know how to get out. Mind you, and one of you guys even pointed out again, Doug was 30 years her senior. She is 24. She's a young mother. I would consider that a young mother by today's standards. Probably not really knowing what to even make of this situation. Just say, okay, like, this is a situation. I still love him. I still care about him. That's where my speculation brain goes. None of this has been testified by Ashley up until this point about how she felt about Doug during this period, but just based on my own experiences and being in similar toxic relationships, I can definitely understand that back and forth feeling of, well, they're being really nice to me, and like maybe things will be different if we do this thing, or maybe he'll treat me differently if I just go along with everything, if I just make peace and I just yes him to death, because then I won't feel any of the repercussions on that end. But again, let me know what you guys think.
You said this peace lasted about 11 months. What broke this peace to your knowledge?
Well, it was my understanding from Doug that they were getting ready to move in.
Let's not talk about what happened with what Doug said was supposed to happen. But during this time, did Ashley stop speaking to him?
I'm sorry, I didn't hear your question.
During this time, did Ashley stop speaking to Doug?
Objection. I'll let you know it calls for hearsay.
Effect on the listener.
Overruled.
Thank you. They continuously spoke to one another for 11 months until August 16th of 2019.
Objection. I thought that was the yes or no, Mr. Objection, non-responsive.
Sustained.
So around this time, you said November 16th?
August 16th
August 16th.
of 2019.
Okay. What happened at this time?
Doug was supposed to be moving in with Ashley and her mother, Alicia. He had moved all these things in.
And we're not going to talk about the specifics of that.
Sir, counsel, I'm sorry to interrupt. You're on.
Which again, Alicia Beyers earlier testified that no, Doug wasn't moving in. And Doug could have told Stephanie one thing and said, "Oh yeah, we're moving in." So that would make sense that she would say, "Oh yeah, Doug told me this." Like she thinks that her client is, innocent in all of this. He's the victim in all of this, and so I could understand like her interpreting it like as, yeah, he said they were moving down to Florida together. So I just believed him. I mean, that seems pretty in line with her current testimony. But backtracking to Alicia Beyers' testimony, she said, no, Doug dropped her off and said, she's your problem now. So,
Okay, I request the
which is also interesting because I feel like the timelines here like seem a little out of order, because when Ashley was down in Florida, Ashley was pregnant. So kind of confused about when Doug would be moving in with her in Florida. Like, am I hearing that right?
What happened at this time?
Doug was supposed to be moving in with Ashley and her mother, Alicia. He had moved all these things in.
And we're not.
Okay, so Ashley was already there, but it's like the way that she's framing it is a little confusing again with the timeline, because Ashley was already in Florida, which would make sense as to why he retained Stephanie Murphy, because she's a Florida attorney. So he was going to move in, but Alicia Beyers said, no, he never lived in my house. Okay. He never lived there, but he could have said, oh, I'm moving in with them.
We're not going to talk about the specifics of that.
Sir, counsel, I'm sorry to interrupt. You're on. I request the instruction from the court about,
Can we not do speaking objections?
Do you need to approach?
So they're going to approach again. And look at that eye roll too. Like, what? Like, I just want to talk about this. This is all I want to talk about. It's like, girl, like, ugh.
I'm sorry to interrupt.
Yeah, I cannot
request
stand
the
this
instruction
woman.
from the court
I cannot
about,
stand this woman.
Can we not do speaking objections?
Do you need to approach?
This eye roll. Like, oh my God, jury, can you believe this? And like the whole time, Ashley doesn't like even look at her. So they're at sidebar again. I think they're gearing up to now have their they're gonna dismiss the jury.
I'm going to excuse you back to the jury room. Again, please don't begin the deliberations.
They're gonna have an argument. The attorneys are gonna have an argument over hearsay. Again, just because of all the editorial, all the characterizations that Stephanie Murphy is making. So
Yourselves, please don't
he's gonna
contact or speak to
dismiss
anyone outside of the
jury
jury.
here.
Use your... All right, the jury's out. You can all have a seat. Ms. Murphy, at this point, I'm going to excuse you from the courtroom so we can have our hearing.
He's gonna excuse Stephanie Murphy. She's gonna leave. Look at the smirk. Like, who are you like, ugh. Ugh, this woman is so gross. This one is so gross. Like, ugh, who are you smiling at, girl? And like that pink is like very bright for television. Like I would have went with a softer color in my opinion, because On the internet, apparently we like to criticize how women look. And in this case, I don't like this particular woman because I think she's just got mean girl energy. So I am going to talk about your dress. And I think it's a little too loud for television, Stephanie. So you might want to tone it down next time you hit the witness stand. But that's just my opinion. And I will not comment anymore on people's appearance unless their name is Stephanie Murphy or Jimmy. Okay. So now they're going to get into their
Well, the witness is out of the courtroom.
hearsay argument.
Do you have,
Judge, I don't have a specific instruction. We may need to craft one, but what I'm looking for, so that the court knows, is an instruction to the jurors that these hearsay statements that have been repeated by the witness thus far, and for purposes of the remainder of her testimony, the other statements she will undoubtedly try to get out, are not being offered for the truth of the matter, but rather being offered for whatever reason that the court wants to ascribe, to provide the context of the narrative in response to the question.
so as I said, go ahead, you want to be heard?
No.
So as I said, I'm not aware of a standard jury instruction in the 2.1 to whatever it is, 2.8 range or 2.9 range that does that very thing. So I want to give the parties the opportunity with the jury not present to look and see if there's a standard jury instruction.
I don't think
I can give it. Like I said, I drafted one for a prior homicide trial where there were a number of statements that were admitted by me, by the decedent, where there were objections, just like we're having now, numerous objections to hearsay. But obviously none of them were being offered by the state for the truth of the matter asserted. That's what was argued, and I made that finding. So in order to have just a blanket instruction, I crafted the following, and the parties ratified it. So I gave it specific to the decedent statements in that case to, it was either an attorney or some sort of financial planner about some final wishes. And here's what it says. You are about to hear statements made by declarant, and I put the name in. These statements are relevant only to explain the reaction and responses that they elicit. That is, the effect those statements had on a reader or a listener, because there was also a letter that was involved. You are not to consider the statements by declarant's name as true, but only to establish the context of readers or listeners' actions, reactions, and responses.
that would be fine, Your Honor.
Except for that you are about to hear, because they've already heard some, so.
So the court want to substitute, you've already heard and may continue to hear. And by suggesting that, I'm not suggesting that I agree to the further admission of hearsay or her interpretation. That's not directly responsive to the question.
So reserving on other objections. And certainly there may be objections you have as we go where you think that they are not being offered for the effect on the listener and that it's hearsay without exception. So those still may come up. All right, so when we bring the jury back in, you want me to give that instruction?
Please.
You have heard and may continue to hear statements made by Doug Benefield to Stephanie Murphy. These statements are relevant only to explain the reactions and responses that they elicit. That is, the effect those statements had on Ms. Murphy.
If I may, Your Honor?
Yes.
I would suggest that it just name Stephanie Murphy, not Doug Benefield, because I think in her testimony it's been broader than that. So I think by identifying the instruction as it relates to this witness, the jurors will consider the testimony appropriate.
All right, so let me go through this again because I have declarant and recipient, reader or listener. So you have to tell me where you're talking about.
Sure.
You are about to hear statements made by Doug Benefield.
Yeah.
These statements are relevant only to explain the reactions and responses that they elicited. That is, the effect those statements had on Ms. Murphy. You are not to consider the statements made by Doug Benefield as true, but only to establish the context of Stephanie Murphy's actions, reactions, and responses.
Okay, so here's my concern. For example, Ms. Murphy also testified about Judge Moreland and about a couple of the medical records and things like that. And I would prefer, and I think the fairest interpretation would be, ladies and gentlemen, Stephanie Murphy has previously said and may continue to refer to out-of-court statements. You are instructed that these statements, if and when made, you should not consider them for the truth of the matter asserted, but rather for context as it relates to Stephanie Murphy's testimony. That's how I think appropriately it should read, Your Honor.
Response?
Judge, I don't really I think these things that he's talking about were objected to and they were stopped. So I don't know that it's better to highlight it anyway, but I don't know if adding names in of people to fit this, statements of Doug Benefield, this person, that person, this person, I don't know that that would be effective to the jury. So I'm a little confused about how to handle it.
All right. Any final thoughts?
No.
All right. I'm open to giving limiting instructions, curative instructions that are suggested by the parties. However, the most recent one proposed by the defense, I don't think is legally accurate. It would be telling the jury to disregard testimony and evidence that's already been presented. I thought the request from the defense, because the objection came specific to Doug Benefield was supposed to move in with the defendant, and that's where we stopped.
Yeah.
So it was my understanding that the instruction that was requested was specific to any statements made by Doug Benefield to Stephanie Murphy, that those are only relevant to explain the subsequent actions and effect that those statements had on Ms. Murphy, and telling the jury not to consider the statements by Doug Benefield as true, but only to establish the context of Ms. Murphy's subsequent actions, reactions, and responses. I don't think the limiting instruction proposed by the defense is the correct one to give. So I'm open to considering language that we can talk about some more, but no, the one you just said I don't think is appropriate.
All right, well, the message that we're trying to give the jurors is that when this witness makes hearsay statements, that the jurors should not necessarily receive that information as true, that it is being offered rather not for the truth, but to show the effect that it had on this witness. After all, that's what this witness is testifying to. She did not limit it just to what Doug told her, Judge. She's referred several times to what she heard from Ashley. She's referred to medical records and to allegations. She's also referred to Judge Moreland's decisions. She's expanded upon them. She's incorporated hearsay into her testimony. This was why I approached the bench before she took the stand. So I anticipated this. That's the way she's conducted herself in the deposition and in all of her prior statements. So what I want.
I feel like she's somebody who just she loves the camera and she wants to be her and she wants to tell her side of the story. And I agree with the defense too. I mean, it's like every other thing. It's like she has a point, and it's like, that's not what you're here for. You're here to be a fact-finding witness. This is what their custody battle was. This is what we filed. This is what the judge ruled. This is when they met. They met on this date. They made peace from this date to this date. Then we were back in court for this thing. Like, I feel like her testimony could have been so much shorter, but because of all of these little nuances that she tried to squeeze in because of her own personal feelings towards Ashley that are just grossly inappropriate, in my opinion, really held up today's entire trial. I don't know. What say you? Let me know what you think. But ultimately, the judge decides to give a jury instruction. So now that we've heard a little bit from the defense, I'm going to fast forward a little bit. And pretty much he just said what he just stated previously, Judge White, that, disregard anything that she said in regards to what Doug has told her. That is hearsay. Just, only take into account what she has said from, again, the facts. This is what happened. This is the evidence. This is what was so let's continue.
Thankfully, Your Honor, on behalf of Ms. Benefield, what I wanted the jurors to understand is that as it relates to Ms. Murphy's characterizations based on hearsay, that they should not receive it for the truth of the matter asserted. Rather, they should receive it to show the impact that it had on Ms. Murphy.
Response.
Judge, first of all, anything that Ms. Benefield said is not hearsay, so it does not qualify under any of this analysis. I do not believe she said anything about medical records. I may be wrong. She did start to mention that she checked herself in the hospital. There was an objection.
You are wrong, because she said, at least in not. Well, you are kind of wrong, because you said the allegations regarding the poisoning were unfounded. So how can you testify to that? You are not a medical expert. that is not your call. Yeah, based on obviously what you may have been presenting in court during your own trial, your own case. Maybe you did find that those were unfounded, but again, you are not a medical expert, so no, you're not allowed to testify to medical testimony, as we saw the shenanigans play out in Norfolk County with frickin' Buchanan giving his medical testimony. I think Tully did at one point. I think Tully was also a weatherman at one point, talking about the weather. Like, ugh. So no, she can't talk about medical testimony, and she did. She did talk about the allegations that were unfounded, and that included Ashley's allegation that Doug was trying to poison her. So that would be, from my perspective, that sounds like medical testimony.
And she stopped speaking. So I would agree that that your idea is correct and that should be the instruction.
Final thoughts.
So everything that a defendant says is not necessarily admissible. It's not necessarily relevant. It's not necessarily an admission. For example, Judge, if during the course of all of this, Ms. Benefield may have stated how much she loved this routine of a mouse named Poco Gigio, I think we could agree that that would have no relevance. And if this witness wanted to get up and talk about that merely because that is something that Ashley Benefield repeated, that wouldn't make it acceptable. So I vehemently disagree with Ms. O'Donnell's statement that anything the defendant says is admissible. And I'm concerned about the editorializing by Ms. Murphy being interpreted by the jury as truth, as unvarnished and documented conclusions. And so I would like the jurors to know basically the definition of hearsay. I would like the court to instruct them that it's not being offered for the truth of the matter asserted. It's an exception, and it can be considered to show how this witness reacted to it. That way, Judge White, it spans the parameters wide enough that the instruction would include hearsay from any source that Ms. Murphy refers to, whether it be Ms. Benefield, whether it be Doug Benefield, whether it be the hospital records or Judge Moore.
All right, thanks both very much. At this point, I don't plan on giving any sort of cautionary or limiting instruction. I've heard the parties agree on language. It doesn't sound like the language I've suggested is acceptable to both sides. So at that point, we'll just continue with the question, objection, ruling. Specifically as to the request regarding editorializing and characterizing, I'm going to sustain on those grounds.
Yeah.
There's been, I think my information in front of me is that Ms. Murphy is a fact witness. All right. The request that I give the definition of hearsay to the jury is denied. As we all know, the determination of legal matters, including whether a statement is hearsay or not, or any sort of evidence is hearsay, that's a judicial matter, not a legal. It's a legal question, not a factual question for the jury. Those are my decisions. I'll note that it is our.
So again, ultimately what he's saying is that, and I think this was a fair ruling, he's not going to give the jury instruction. He's not going to tell them what hearsay is, because that is not for them to decide. It's for the judge to decide and rule based on what he believes is considered hearsay or not, which I think is fair. But he is going to sustain, any kind of characterization or editorialization that Stephanie Murphy makes, because she makes a lot of them and because she has a lot of opinions, it seems like, and she wants to be heard. But girlfriend, you save those opinions for when you go to the press, and you have been a busy bee. She has been interviewed by Court TV. Creepy cousin Tommy Benefield, creepy Tommy and creepy Stephanie, both of them just love to be on Court TV. So I wouldn't be surprised if she does another interview about this. So let's skip ahead. They bring her back in. The state continues with direct examination.
Characterizations of observations as opposed to observations.
Okay.
So just FYI, I did sustain those two objections.
Okay.
Otherwise, we're just going to have to keep adding questions and answers. I'll rule on objections as we go.
Great. Thank you.
Go bring the jury in.
Thank you so much. Like, girl, and like, she knows she's an attorney. She knows what she's doing. She's just trying to squeeze in whatever little bit she can. And I'm so glad the judge said it, because she is a fact-finding witness. Like, you were just there. Your testimony could have been half this time. if you didn't try to pull all these different shenanigans, you and the state colluding to make all these shenanigans. But
Of that, did you ultimately file anything on Doug's behalf?
I ultimately did, yes.
Okay, and what was that?
We filed actually think back, it was so many years ago now, a series of things, but one of the first things that we filed was an amended petition for divorce. And so it was actually a motion for leave to amend with the amended petition attached to it, which is the procedure.
So that ultimately means it was not seeking divorce before, but now the petition is.
Yes, that's correct. And still the parenting plan with some additional allegations, but that's what the main first pleading was.
Okay. And at some point after this was filed, did you get information that there had been complaints filed against Doug Benefield?
Yes, I did. So that amended petition was filed, I think, November 6th or 5th of 2019. And then within a month, I learned that there was a series of complaints filed with.
Object, hearsay.
I'll sustain.
Ultimately, these complaints that were filed against Mr. Benefield, were they documented or filed in any way in your casework, in your cases?
Object, relevance.
I'll overrule.
So of course we didn't attach them as exhibits to our next pleading, but we did file an amendment.
Object, editorialized.
Sustain. That would ask for a yes or a no.
Okay.
Can you repeat the question for me?
Those complaints, did they make their way, the information at least, into your filings in your cases?
Yes.
Okay. At some point, did Ashley file an injunction request based on these allegations?
Yes.
Okay. And around this time, was there a psychological evaluation ordered with Dr. Broder?
It was not ordered by the court. There was a psychological evaluation that was put into place through, I believe, the child protective
Objection,
team.
editorialized. How many
Sustain.
times?
So an evaluation was recommended.
I sustained it.
I requested instruction from the court to disregard the last answer.
Members of the jury, I've sustained an objection. When we had our initial instructions, the preliminary instructions on Monday morning, I want to remind you of one of those very important instructions. If an objection is made,
yeah, I'm glad. Like I feel like the judge did a really good job in terms of ruling on this specific witness because yeah, you can tell, and she's well aware of what she's doing. That's the frustrating part. It's not like she's a doctor or somebody who doesn't probably testify a lot in court or somebody who isn't a trial lawyer like you are. Like you know what you're doing and what you're saying. So I don't understand why she's having such a problem keeping it all in. She seems very like almost she's ready to explode with what she wants to say, what she has to say. And you'll see that kind of energy too a little bit later with Dr. Quintel, but more in the favor of Ashley's case because I think he's the psychologist. Not they're talking about Dr. Broder, but he's another I think psychologist that also observes Ashley and Doug as well too. So essentially, what they're saying is yes, was an evaluation, a psychological evaluation recommended? Yes or no? Yes or no? We don't need to know if it's court ordered or not. Yes or no? So I think he did a really fair job in terms of that.
you're not to guess or speculate as to why it was made. Life has been sustained, and the witness has been allowed to answer. Go ahead.
As part of the process of these cases in court, did Ashley and Doug Benefield, to your knowledge, see a Dr. Broder
Yes, they did.
for a psychological evaluation?
Yes.
Okay. Do you know when this petition for injunction filed by Ashley was set for a hearing?
I don't remember the date that it was initially set because she filed a motion to continue.
Objection,
Basis.
editorializing, not responsive to the question.
Ooh.
It was continued several times after she filed a motion for mediation, and then eventually it was scheduled to occur. I believe it was September 30th of 2020.
Okay. So you said it was continued several times because of a mediation. So just what is a mediation and how?
So that's really important. That date, September 30th, she says, I think it was scheduled for September 30th, this hearing with Dr. Broder's report. And we will hear from Dr. Broder in just a little bit. But again, keep that date in mind because when was Douglas Benefield shot? The 27th, which fits perfectly in line with the prosecution's timeline in trying to prove intent. So just pay attention to those dates.
What is that? How does it play in?
Okay, so mediation is a settlement conference that takes place. It generally involves the parties as well as their attorneys, and then a neutral person who's generally a certified family court mediator. And so what it generally happens is a mediator goes back and forth between each side to try to work out an agreement. And in this case, it was ordered by Judge Moreland in response to Ms. Benefield's motion.
To do the mediation.
Correct.
Okay. And did you participate in the mediation?
I did, of course.
And also Doug and Ashley Benefield.
Yes.
And as a result of that, did some of the focus of the hearing coming up change?
In anticipation of the mediation, yes, the focus of the upcoming hearing on the 30th changed.
Okay. And in what way did that change?
Earlier in September, I think on the 17th, Doug and Ashley signed a joint motion to release the psychological evaluation reports in the divorce case, in the 2018 DR 2318 case. Because in that situation, the psychological evaluations had not been ordered by Judge Marlin. They were put into place through.
Objection. Response, so that editorializing.
I'll sustain on the narrative.
So they did a joint motion to release the psychological evaluation.
Yes.
And is that fairly typical? It's needed in this realm to get that result released to the parties.
Oh, of course.
Objection, relevance, it's what's taking place in this case.
A judge would not just really, is not able to, oh, I'm sorry, Judge, I apologize.
A judge doesn't release that report unless.
The judge orders that it can be released.
Okay. And Doug and Ashley did a joint motion for that to happen.
They did.
And to your knowledge, what was their path forward from that point?
The path that went into place was they were reconciling and moving to
Jack's
Maryland.
speculation as to what the path forward was.
And so when we were leading up to the week that he was killed, it was agreed upon that they were going to result in an impasse of the mediation because they were reconciling. And then the hearing on the 30th, the week after, was only going to be to release a psychological evaluation report.
Okay.
And they were going to pursue the move to Maryland.
So ultimately,
Okay, so according to Stephanie Murphy, remember, September 30th, the hearing was supposed to only be focused around the release of the psychological report conducted by Dr. Broder, again, who we're going to hear from in just a little bit. But interestingly enough, that is not what Ashley Benefield's attorney testifies to later on. Actually, that was in today, day 4, and we'll get to that in the recap. We'll probably reverse back into time and come back to this testimony. But it's really interesting, isn't it? Isn't it? So at this point, it's a fact-finding witness. We're taking it in. We're believing what we hear. Okay, this is what September 30th was about. Are there any receipts of it? All we can take is just the testimony from the witness. So do we have receipts of that?
the only thing that was
Confirming it.
supposed to happen at this hearing on September 30th was the release of the psychological evaluation.
That was it.
That was it. Okay. And do you recall what day of the week that was, September 30th?
I believe it was Wednesday. So mediation was a Thursday prior to the killing. And then the hearing was supposed to be Wednesday, the 30th,
Okay. And what day was Doug killed?
Sunday night.
And that would be the 27th?
Yes.
And who was the judge going to be at this hearing on the 30th?
Oh, it was still Diane Moreland. She was still the judge on the case.
And at all times that you dealt with Doug, did he ever seem to you overly angry or aggressive about things?
No, I thought Doug was never angry. He was very mellow and matter of fact. It was a point of contention between us, actually.
Okay. I have no further questions. Thank you.
Thank you.
Cross.
Such a bizarre comment. It was a point of contention between him and I. I mean, of course he's going to be nice and kind to you. One, he's retaining you. He's paying you. Not that like every client is easy to work with. I mean, if you guys have been following the Sarah Boone case, she's fired, 8 or 9 lawyers at this point. That's a fascinating one that I might dive into next when that goes to trial because she's supposed to represent herself. And holy smokes, that's another Florida case. What's going on, Florida? What's going on with you guys down there? But a lot of interesting stuff. So again, if you're tracking you're picking up what the prosecution's dropping, they're trying to prove that whatever was in the psychological report, Doug wasn't worried about it. I mean, she didn't directly ask this witness, was Doug worried about what was in that report? No. But they're trying to allude to the fact that, hey, he was killed 3 days before this hearing. So Ashley must have been really nervous about what was going to come out in that psychological report. Like, oh, she's this crazy person. Which at this point, there's been no evidence to claim that she is crazy or that she has, and I don't even like using that word, but like she has like any kind of mental disorder or she has just anything psychologically off that might be concerning, something that she would be especially worried about coming out in the psychological report. There has been nothing. So all of these claims, all of these allegations so far have been towards Doug, have been about Doug, never Doug alleging this, that, and the third about Ashley retaliating in any kind of way or doing some kind of psychological warfare on him. So I find it interesting. But now we're going to get to cross Stephanie Murphy, and it's going to get spicy.
Yes.
Good morning, Ms. Murphy.
Good morning, Mr. Taylor.
We've met on a few occasions, have we not?
Yes, we have.
And we meet again this morning.
It's lovely to see you.
So your specialty is family
No,
court.
it's lovely to see you. Like, she's so condescending. I really don't like this woman. Ugh.
Family law, yes.
And you've been practicing family law, I think you've told us 23 years. You have your own firm, you and your husband.
Yes.
And in that capacity in family law, correct me if I'm wrong, but when you litigate matters in family court, excuse me, there are
In a sip of
rules
water.
and procedure that apply to family court, are there not?
In all courts, including family court, yes.
Okay, such as the rules of evidence,
Yes.
the rules of procedure, family court procedure,
Yes.
and ethical obligations as well.
That's correct.
Those always govern your behavior with respect to the tribunal, the court, correct?
All of our behavior, yes, that's correct.
Are you familiar with Florida Bar Rules of Professional
Objection,
Conduct?
relevance test?
I'll overrule.
Yeah.
I don't know where this is going, so I'll overrule for a moment.
Thank you.
Sure.
Are you-
I'm familiar.
Yeah, Rule 4-3.3, candor toward the tribunal.
I'm familiar with that rule.
All right. You're familiar with that rule's obligation of a duty to disclose false evidence.
I don't have the rule in front of me, so if you want me to read and see if that's exactly in the rule, I can certainly take a look at it. I'm generally familiar with the obligation to provide candor to the court.
Yes, and to
Well, you just said you were familiar with it, but now she's got to elaborate a little bit more. Can you smell Jen McCabe? Are you guys buddies? Like, are you also Googling house long until I get off the witness stand? Like, what? Are you guys besties? Are you buddies? Has she got friends? She got a girlfriend in, like, Florida? Like, I need to look at this. Like, oh, if you refresh my memory, but before, you seem to have, like, the date and time for everything, the case numbers memorized. So interesting, your selective memory.
disclose
That's
if
amazing.
evidence is inaccurate. I think
Yes,
we can
exactly.
agree on that,
Of
correct?
course.
That would include, would it not, a failure to correct a materially false statement of fact?
Yes, I'm aware that exists, but I don't see how that could apply to my case with Doug.
All right, well, let's see. I want to ask you about a sequence of events now relating to the litigation that you mentioned to us between Doug Benefield and Ashley Benefield.
Was this the injunction you're referring to or the divorce case?
I'll be very specific in my questions, if you'll be patient for a moment.
Of course.
Ashley Benefield files her domestic violence petition on April 23rd of 2018. Is that correct?
I believe that day is correct, yes.
Just so there's no mistake. She then, correct me if I'm wrong, because you seem to have the dates mastered. Ms. Benefield then files a petition for divorce and temporary TPR on May 31st of 2018.
I don't remember the date that she filed those, but she filed, those would be, I think, separate things. And so in response to the petition for parenting plan unconnected with divorce that I filed on Doug's behalf, she filed an answer and a counter petition seeking divorce.
So your answer for purposes of my question was you don't recall the date.
Yes, that's correct.
Okay.
And it wasn't that
Can I
she was,
approach the witness?
Yes.
See if this refreshes your recollection as to the date.
I need to get my reading glasses. Mr. Tate.
She brought her reading glasses. You don't need to borrow Mr. Taylor's.
While you're looking at it, when I refer to the initials TPR, what does that stand for?
Termination of parental rights.
Okay.
Yes, thank you for the reminder. You're right. This is the 31st of May. And she did file a separate case. I had forgotten that.
Well, the question pending was, does that refresh your recollection as to the date?
As to the date, yes, the
Yes.
contents. No.
Was I correct in my statement to you that the date was May 31st, 2018?
Yes.
Now, would you take a look, if you need to refresh your recollection, as to count 2, specifically paragraph 5? Ms. Benefield makes some allegations there, does she not?
She does.
All right. On June 19th of 18, you file Mr. Benefield's answer.
I don't remember that.
May I approach?
Yes.
Let's see if this refreshes your recollection.
Thank you.
Is the date June 19th, 2018?
Yes, that's correct.
And that's your answer, is it not?
This is Doug's answer that I drafted and filed on his behalf.
That you
Yes.
drafted and filed on his
Yes,
behalf.
correct.
And in response to paragraph 5 of Ms. Benefield's petition, you deny it, do you not?
Objection relevant, sir?
I think,
I'll overrule on those
yeah,
lines.
thank you, Judge. Ms. Murphy, my question was, if you would look at paragraph 5, do you enter a denial?
I'm sorry, it's number 5 is 7 pages long. So I was just checking to see if that was correct.
Well,
Yes, we denied these allegations
Okay.
that he committed those acts during pregnancy.
Now, as part of that action, your client, Doug Benefield,
Those acts, so the poisoning, I'm assuming.
submits to a deposition 27 days later on July 17, 2018, does he not?
I don't remember that exact date, but he did submit to a deposition around that time frame.
Okay, and in that deposition,
Objection,
while,
pretrial motion.
Sustained.
Your Honor, she opened the door. She's already talked about,
Maybe
Would you like to approach?
yes.
She did. She did open the door to that. So now they're going to approach. I think it's a pretty hefty sidebar. I don't know if this takes us. I can't recall. Oh, it might take us to this
Go
portion.
back downstairs to that joint right now. All right, members of the jury, here's what we're gonna do. I'm gonna go ahead and let you go to an early lunch. It's about 11.
So yeah, so the judge dismisses so the lawyers can argue some more. I think they dismiss. Oh no, everybody goes on break. Everybody's on lunch. Then they go to arguments on impeachment. So we'll watch a little bit of this.
Okay. All right, then let's finish up this impeachment argument, and then we'll get the jury. At this point, I've asked for the jury to remain downstairs in the jury assembly room, just
We'll
it's more
finish up
comfortable.
with
The
Tiffany
chairs are more comfortable. They can
Murphy's
spread out. They have vending machines and so
testimony.
forth. So, all right, it's your objection.
Specifically, I am objecting to the manner in which the defense is trying to impeach this witness. I just want to frame an issue. This witness's character or bias based on what we spoke about before. First of all, I would say character is never appropriate for impeachment. I do have case law on point, but I think it's pretty clear that the only evidence of character that is allowed for truthfulness is reputation, and specific acts of untruthfulness are not allowed. So character, I do not believe, I don't know if the word was just used interchangeably, but I do not believe character has any part of this, and attacking character is not allowed. As to bias, I do not understand how what the defense is trying to do would achieve any bias. No ethical obligation or ethical complaint was ever filed. Even if one was filed, I don't know that that would be allowed to come in this case in this manner. I found no case law to say that that type of information could come in. But I also have objections to the manner in which this is trying to be done because, number one, Stephanie Murphy testified that the original petition for injunction had allegations of X, Y, and Z. Later, the defendant filed for, I think it was divorce, and alleged X, Y, and Z. I think what the defense is trying to say is that this attorney denied that allegation that was alleged in this petition after this attorney had been at Doug Benefield's deposition, implying that Stephanie Murphy knew different, but yet she still denied that paragraph of the petition. I have so many objections to that, but mainly I think even if that type of thing were allowed, this is like a motion to dismiss in criminal court where you admit a paragraph, you deny a paragraph. It sounded like she said that paragraph, number 5, was 7 pages. So I can't imagine anyone agreeing to a 7-page recitation from the other side. So I do not think it stands for what the defense is purporting that it stands for. But even if it did, I do not think it's.
But you don't think that girl wasn't memorizing this stuff? Like, she is living and breathing this case. She's already been on court TV like 4 or 5 months ago, like with creepy Tommy Benefield. So the two creepy twins, they were both. So I speculation brain, but she knows what's in there. She knows she's been living and breathing this case probably since 2020, since she knew she was going to be deposed and called as a witness. So yeah, she probably knows the ins and outs, and she knows exactly what she's doing because she's an attorney.
It's appropriate for impeachment.
Defense?
Okay, so here's what we know. And by the way, if I use the word character in referring to this, I was mistaken and I meant to say credibility. Here's what we know regarding Stephanie Murphy's testimony. She acknowledged that Ms. Benefield filed this domestic violence injunction petition, and she specifically mentioned a couple of the allegations, or may recall in particular, shooting the gun in the kitchen into the ceiling, punching the dog, and potentially suspecting that she was being poisoned. So that the court appreciates my position. The fact that she mentioned 3, my position is it opens up the entire petition. She doesn't get limited to just the 3 she chose to mention on her direct, because the stakeholder, they open that door. It's before the jury. I'm entitled to rebut it and probe it.
So what he's saying is, I mean, this is a 7-page document filing, whatever. It's not just those 3 allegations. There's 7 pages worth of allegations, aside from, again, the 3. He punched the dog, he shot the firearm in the kitchen. I think he probably also mentioned too, him throwing the cat, him punching walls. The poisoning is the big one that they already mentioned earlier. So, and the list goes on and on. So that is what the defense is saying, is she opened the door for that. So like, why can't we cross her and ask her about that?
For credibility and bias. Now, with respect to what Ms. Murphy did or failed to do, she comes before the jury and announces herself as an attorney and that she's representing Douglas Benefield. She then responds to Ms. Benefield's petition, where these things are alleged, this inappropriate conduct, abusive conduct, if you will. And she denies that paragraph in Ms. Benefield's pleading, specifically paragraph 5, that Judge White lists all the horribles, the domestic violence horribles. So it's our position, and so that we're clear as to how I perceive this should unfold. She then never corrects the record, regardless of whether it's a violation of a code of conduct, which I do think is impeachable, to show bias and favoritism, and to show failure to act within her expected realm of conduct. But in addition, 27 days later, she is present at the deposition of her client, where he admits to all of these: shooting the gun, punching the dog, knocking the dog unconscious, punching holes in the wall, throwing a loaded firearm, I believe perhaps putting a tracker on the car, whatever it is, he admits to it. I am entitled to ask her why, in light of that, she never advised the trial court that her client admitted to this conduct, and why she didn't bring that to the trial court's attention. She never did. So it's not that I am particularly...
So hiding evidence. And we know that very well from the Karen Reed case. The misreporting by Proctor, leaving certain things out, certain names out, certain people out of certain reports, changing reports. So this is interesting.
Determined to show that she violated the code of conduct, which again, I do think I should be entitled to ask, but merely to show that the trial judge, I will ask you this question also, the trial judge wasn't at the deposition. So the trial judge never knew about these admissions. Now keep in mind, this is what she's presented to this jury. I am trying to rebut that. I am at least trying to cast doubt on that witness's credibility. I have 2 cases
Their
in
argument.
particular, in an effort to respond directly to Your Honor's request. No, I could not find a case where a lawyer was called as a witness, and based upon cross-examination of the lawyer who failed to follow a particular code of conduct, impeachment was allowed. What I do have, however, is typical scope of cross-examination as it relates to professionals and as it relates to lay people. I want to mention the cases to the board, and then I'd like to read what I think is the relevant section. So the first one is Mendez versus State. It's a second DCA opinion. It's dated April 21st, 1982.
He's going to read some case law. I'm just going to kind of fast forward it a little bit to the judge's ruling. Ultimately, I can't actually recall how he ended up ruling in this regard.
And this may be the case that says it does find ready should testify a certain way, and move on.
I stated differently. If an attack that Ashley Benefield bought, the court has already that type of opens the door.
So the procedures that I follow, whether it's a motion hearing, an objection, and that is the objecting party goes or the moving party goes, tell me everything you want to tell me. And then I go to the other party, the non-moving party, or the party in this situation that's the proponent, and I say, tell me every argument that's in favor of you, and then I go back for rebuttal. And the reason I follow that process, and I've been very clear, and I've always followed that process, is because otherwise it would just be back and forth and back and forth and back and forth. At some point, I have to make a decision and move on.
Yep.
All right. In this particular situation, as with all cross-examination, multiple factors are at play for any particular witness for impeachment purposes on cross-examination. Their perception, where they were, what they could see, what they could hear. There's 5 senses. Their memory of that, their ability to recall, their ability to communicate, their bias, any motivations they may have to testify a certain way, prejudices they may have, interests they may have in the outcome or a particular ruling, prior inconsistent statements, prior convictions. There's another number of avenues. And that's explained further in the case law. I have not been provided a case on point for this particular scenario. So as Mr. Taylor has astutely pointed out, whatever ruling I make may very well be the subject of an appeal to the Second District Court of Appeal. They may find I did something wrong or let something in I shouldn't or kept something out I shouldn't. And that's just the nature of trial work, the nature of being a trial judge and making decisions on the fly. But I'll frame this one up as best I can so it's ready for the appellate court. I find that the current avenue of impeachment of Ms. Murphy is improper. I'm going to sustain the objection. I find that it is improper impeachment to attempt to get in the victim's statements made in a deposition in a civil case unrelated to the criminal case through the impeachment of his attorney in the civil case based on an allegation that she violated a rule of professional conduct by not amending her answer to his complaint when it is alleged that she subsequently became aware of contrary information. I find that it doesn't provide any basis for impeachment under the existing case law, and this may be the case that says it does. All right.
I mean, and that's a good point too, is like if there isn't any case law currently in regards to something like this, then yeah, there should be case law created because I think that's totally impeachable. But he's teeing it up because he's like, I know this is probably going to be appealed if this verdict ends up not going in the way of the defense's favor and Ashley ends up getting convicted for second-degree murder. This is totally, in my opinion, an appealable offense. The fact that she's purposely omitting information, like leaving certain information where your client is admitting to doing all of these things. Not only that, we just need that. I mean, that to have that in a deposition presented in front of the jury, like that's huge for the defense. That is a huge point, and the prosecution had a huge win here. And this is a big win for the prosecution because it's just more information that doesn't come into play, and it doesn't shut down the credibility of this witness. So I definitely don't think that the judge, in my opinion, ruled fairly in this particular. But he's saying, you know, I know that this is probably going to be appealed, so maybe I didn't rule right. So at least, like, that's why I don't really have a big problem with this judge. I mean, definitely more fair than Bev by far. But let me know what you guys think. Do you think this ruling was fair? Do you think that this witness should have been impeached because of the evidence? And I can understand, I guess, to a point, like that had to do with the civil case, not a criminal case. So I guess I could kind of understand it from his perspective, but still, I think it's completely irrelevant. I mean, this just correlates with the history of Ashley and Doug's relationship, what they were going through, all these different hearings and court proceedings that they were going through, and the back and forth between their soon-to-be divorce, their custody battles. I think it's completely irrelevant and totally unprofessional that Stephanie, because she knows what she's doing. She knows exactly what she's doing. She purposely left that information out, but it's neither here nor there, and it doesn't matter. So let's get back to the Pink Panther on the stand.
You're under oath. I also this is Leah.
Pick up back on cross. Okay, they bring in the jury.
Pretty much crossing some legal topics. We've heard.
Told us September 20. Thank you, Judge White. Ms. Murphy, we've pretty much established that the homicide occurred on September 27th of 2020, correct?
That's my understanding, yes.
Okay. And then you've told us here today that Dr. Broder's report was set to be released 3 days later on September 30th. Is that correct?
Yes.
All right. And the inference by you in the state's theory is,
Objection?
Overruled.
so I'm sorry, Judge, was that overruled?
Overruled.
Thank you. The inference by you and by the state's theory is that Ms. Benefield then killed Mr. Benefield to stop the release of Dr. Broder's report.
Yeah.
Are you asking if that's what I believe or if that's what the state's inference is?
Well, you've discussed the matter with Ms. O'Donnell, have you not?
I have, yes. Yes, I have.
And in fact, she's provided you with all the documents in the case, hasn't she?
I don't know if she's provided me with everything, but I have gotten a lot of documents in the case.
By direct conversations with Ms. O'Donnell.
Yes, I did a
Okay.
discovery request.
And so is the implication not that, as you testified before the jury earlier, Ms. Benefield shot and killed Mr. Benefield because of this report that was coming out by Dr. Broder 3 days later?
Absolutely, I have no doubt.
Okay, so that's the theory of the.
Absolutely, I have no doubt. And guys, remember that she said that because again later when we get to Faith Brown, the attorney for Ashley Benefield's testimony, it completely contradicts everything that she just testified to. In regard to this specific hearing, what was going to be the focus of the hearing, when the hearing was going to take place. But yeah, I mean that is, I mean, it's plain as day. That's why I find it funny that the prosecution was trying to object on this. I was like, this, you literally stated your theory in opening statements. It's not a secret, and you could just see like the just absolute hate towards Ashley Benefield, and I feel like it gives off just so many similar vibes from the Karen Reed case, and just these people, these witnesses, these people's personal feelings towards Karen Reed just being the be and all of everything, and totally making their minds up. I mean, it's just absolutely insane. But yeah, she's like, I have no doubt that's the reason why Ashley fatally shot her husband.
Homicide.
Right.
All right, so I want to pass you some emails, see if you recognize them.
See how big her eyes got too? Like she's like wetting them.
Yes.
So they're gonna approach about the emails. Oh my god, yeah, we gotta like look at some of these facial reactions actually, because they're pretty good. Like the eye rolls. Oh my god, you're just so unlikable, lady. The uncomfortable smile. I mean, I get it. Like you have people, like I don't want to judge too hard because one, I've never been on a witness stand, and it's probably extremely awkward being on there and people just staring at you and you not knowing where to like look around. So I do feel that. But the eye roll, like, come on now. Like the jury can see you. So now she's going to take a look at these emails. She's like carefully looking at it too. Like exactly like when Proctor was looking through every single page of like some of his reports, and you just take his sweet old time. He wants to go through every single thing. The same vibe. She just takes her time going through the emails.
Okay, so I have a series of simple questions for you. Do you want to reconsider whether or not the release of Dr. Broder's report was set for 3 days following the incident?
It was agreed with.
Do you want to?
No, I'm not going to
Answer
revisit
it.
that.
You can answer and then explain if you like. I'd like your first answer.
I'm not revisiting the answer. My answer is the same. It was set for the 30th, 3 days after.
Okay.
And I can explain further.
Okay, so she's locked into that date, the 30th. He's like, I'm giving you an opportunity to like change your statement. Like, I'm giving you that chance right now.
You want to hear more?
No, that's fine. As long as
That's
you've reviewed that,
perfect.
it refreshes your recollection, I trust.
It does. I don't think it's a complete conversations, but yes.
Yeah. Okay. Now, is it not a fact that Dr. Broder, on the 3 days following the event, was on vacation?
What event? The murder?
Yes. The 3 days following the event that this report was to be released, is it not a fact that Dr. Broder wasn't in town? He was on vacation.
I don't think that's correct. I think he was on vacation the week prior, but I don't know. I try to remember everyone's vacation, but this was a lot of years ago.
Is that document in front of you contain emails between you and,
Objection? Relevance.
does that document that you were holding contain emails between you and Judge Moreland's judicial assistant?
As well as other people.
But that's not what I asked you. I asked you, does that document contain emails between you and Judge Moreland's judicial assistant?
Not only, but yes.
All right. And
Just
you
yes or
still
no,
maintain,
girl.
after reviewing that the hearing was set for release of Dr. Broder's report.
Dr. Broder was returning from his vacation on the 23rd. So if you look back
Not
through the emails,
not responsive to my question,
Objection,
Your Honor.
Judge, let her answer.
She's editorializing. I asked her for a simple answer. She can feel free to explain it after if the court feels that's appropriate.
I'll sustain it. Call for a yes or no.
No, and that's, boy, I'm saying she's, okay,
No, he called for a yes or no. So
Oh, okay.
your objection,
it's sustained. Got it. All right, so is the answer to my question yes?
can you repeat the question?
I knew you were going to answer me that.
Well, I want to be accurate.
Can I ask the court reporter, Your Honor, to read the last question back?
go ahead, ma'am.
I want to be
And you still
accurate.
maintain after reviewing that the hearing was set for release of Dr. Broder's report.
Yes.
Now, could we agree, if Dr. Broder was out of town and not available, and the court would not entertain the hearing unless Dr. Broder was present, could we agree that that hearing 3 days later would not take place?
Mr. Taylor, I don't think you read the emails correctly because the hearing that her assistant was referring to was a hearing to take place on the 23rd when Dr. Broder was not available because he was on vacation. I'm talking about the hearing that was on the 30th when he was available. That was 3 days after your client killed my client.
And it's your testimony then that the hearing would have taken place.
Had he been alive, yes. On the 30th, not the
Yes.
23rd, which is what I think you're
All right.
confusing.
You referred to a letter that you sent to Ms. Benefield on March 14th, 2018.
My memory is that it was the 15th.
So she's saying that Dr. Broder was back from vacation. That's what I'm a little bit confused on. Like, I gotta go back because she's like a word salad sandwich.
Now, could we agree, if Dr. Broder was out of town and not available, reconsider whether or not the release of Dr. Broder's report was set for 3 days following the incident?
It was agreed with.
Do you want to,
No, I'm not going to
Answer
revisit that.
you can answer and then explain if you like. I'd like you to first answer.
I'm not revisiting the answer. My answer is the same. It was set for the 30th, 3 days after.
Okay.
And I can explain further if you want to hear more.
No, that's fine. As long as you've reviewed that, it refreshed your recollection, I trust?
It does. I don't think it's a complete conversations, but yes.
Yeah, okay. Now, is it not a fact that Dr. Broder, on the 3 days following the event, was on vacation?
What event? The murder?
Yes. The 3 days following the event that this report was to be released, is it not a fact that Dr. Broder wasn't in town? He was on vacation.
I don't think that's correct. I think he was on vacation the week prior, but I don't know. I try to remember everyone's vacation, but this was a lot of years ago.
Is that document in front of you contain emails between you and,
Objection? Relevance.
does that document that you were holding contain emails between you and Judge Moreland's judicial assistant?
As well as other people.
But that's not what I asked you. I asked you, does that document contain emails between you and Judge Moreland's judicial assistant?
Not only, but yes.
All right. And you still maintain, after reviewing that the hearing was set for release of Dr. Broder's report.
Dr. Broder was returning from his vacation on the 23rd. So if you
So she's saying he was returning from his vacation on the 23rd because he was, I guess, I mean, you said you didn't know when he was on vacation before. You said, I think it was the week before. I try to remember people's vacations. So you don't know. But then you say you believe he was returning back from vacation on the 23rd.
You look back
Not
through the
responsive
emails.
to, not responsive to my question, Your Honor. She's editorializing. I asked her first.
Also stated, call for a yes or no. So
Oh, okay.
your objection,
Can you repeat the question?
Last question.
And you still maintain after reviewing that the hearing was set for release of Dr. Broder's report?
Yes.
Now, could we agree if Dr. Broder was out of town and not available, and the court would not entertain the hearing unless Dr. Broder was present, could we agree that that hearing 3 days later would not take place?
Mr. Taylor, I don't think you read the emails correctly, because the hearing that her assistant was referring to was a hearing to take place on the 23rd when Dr. Broder was not available because he was on vacation. I'm talking about the hearing that was on the 30th when
I want to backtrack again.
Mr. Taylor, I don't think you read the emails correctly, because the hearing that her assistant was referring to was a hearing to take place on the 23rd when Dr. Broder was not available because he was on vacation.
So you just completely contradicted what you just said, my sister. Like my girl, you just said you believe he came back from vacation on the 23rd after you said you think he was on vacation from the week before, but you don't exactly know because you try to remember people's vacations, but it was so long ago you can't remember. Fine. But then like 3 seconds later you say he was on vacation. So on the so what exactly are you testifying to? Was he not on vacation, or was he on vacation during that time when this report was supposed to have dropped?
I'm talking about the hearing that was on the 30th when he was available. That was 3 days after your client killed my client.
And it's your testimony then that the hearing would have taken place.
Had he been alive, yes. On the 30th, not the
Yes.
23rd, which is what I think you're
All right.
confusing.
I think you're also confused because I'm
You refer to a letter that you sent to Ms. Benefield on March 14th, 2018.
from your client.
My memory is that it was the
killed my client.
15th of March, but if you have it, that would certainly help. And do you have the email that was sent with it?
No.
Suddenly she doesn't remember.
Okay, this is not the letter that I sent. This is a draft of a letter.
Mhm.
The letter that I sent on the 15th was on my letterhead, so this is not the letter.
Okay. The letter that you did send on the 15th, I think you told us, if I'm not mistaken, was an effort by you on Doug's behalf to advise Ms. Benefield, among other things, that he wanted to try to work things out.
No, I don't think that's correct. No, that's not what I said this morning, nor was it the intention of the letter. And I don't have the actual letter I sent to verify that there was nothing about reconciliation. The letter was about whether she would agree to him being present for the birth of his child, what was supposed to be the next month.
All right. So you sent the letter to see if she was willing to have him present for the birth of the child.
Yes, that's right.
We're in agreement.
Yes.
Were you aware whether or not there was any prohibition at the time that you sent that letter from Douglas Benefield coming in contact with Ashley Benefield in any capacity?
I'm aware that there was an injunction that was entered by mutual agreements. It was what people refer to as a mutual restraining order out of South Carolina.
Correct. And it was in effect at that time, was it not?
It was. They would have had
So
to have a
that-
written agreement modifying that.
So that would have prohibited Mr. Benefield from being present with Miss Benefield, would it have not?
No, I don't have the South Carolina order in front of me, but my recollection.
do.
Oh, that would help if I could see it then.
May I, Your Honor?
Jen McCabe. It's the Florida
Here's the
pink
transcript.
version.
Here's the order.
She reminds me of, if you guys watched Orange is the New Black, the I don't remember, I think her name is Linda. Oh my god, I forget what his name is, but I think the guy who is I can't think of like exactly what is Joe, the warden, his girlfriend later on in the season, who like during the siege or whatever, she ends up becoming like an inmate for a little while. She looks like her, and I cannot like stop thinking about that. I don't know why. Sorry, random thoughts. So she's gonna look
November
at
3rd,
November
2017.
3rd. And you were aware that the order was entered for a period of 6 months, correct?
Didn't you hand this to me for me to look at?
Sure.
Okay.
why else would he have handed it to you? He didn't want you to look at it.
Takes place. Okay, so what's the date that the hearing takes place?
The hearing took place on November 3rd, 2017.
And at that hearing, Doug was present.
It appears so, according to the order
Right.
that was entered.
And
10
if
days
you,
later.
if you look at the last page, I believe paragraph 2, the judge
I'm
orders.
going to object to going through this hearsay piece of paper.
Are we only talking about the order?
Right now, she's looking at the transcript.
No, this is the order.
Okay, the order.
If it's a court order and you're asking the witness to interpret it, I think that's okay. I think she's demonstrated that she has sufficient experience, training, and knowledge.
So the hearing concluded on the 3rd.
It appears that it did. I wasn't there.
Yep.
This was before my time.
But you were aware of that when you sent the letter to Miss Benefield. In other words, you knew you were sending the letter because Mr. Benefield was not allowed to communicate with Miss Benefield. Wasn't that why you sent the letter?
No, that's not why. Maybe that's why he didn't send her a letter, but that was not the reason why I sent the letter. I sent the letter so that there was a formal request, not in between the two of them directly.
Would you agree that had Douglas Benefield asked that of Miss Benefield, it would have been in violation of that order?
We'll sustain.
Let me pass to you, if I can,
Yeah, whatever.
this document.
Yeah, whatever.
That the release of the matter being heard 3 days on September 18th of 2000, that the only matter being heard 3 days later on September 20th was the injunction, not the release of Dr. Broder's report.
Now, I think you're getting the dates confused again. So this was September 18th, was this email talking about the judge setting a hearing on September 23rd, because in this email, she did say the only matter being heard on September 30th is the injunction. That changed after this time. And you don't have those emails, apparently.
Do you?
Well, no, I don't have my file with me. It's 3 boxes worth of documents. But before we even went to mediation, it was agreed and the court was advised that we were going to be addressing only the joint motion for the release of psychological evaluation.
Which was not said on that day, correct?
You mean the 23rd, which is what they're talking about in this email?
Yes.
Right, it was not said on the 23rd. Dr. Broder was on vacation.
Okay.
It was going to be said on the 30th.
Did you know whether or not Doug Benefield sent a package to Miss Benefield in November of 2017?
I don't remember the date. I know that he did send her a package before this order was signed, but after the hearing took place in South Carolina.
Okay, so after the judge ordered no contact, he sent her a package.
My understanding is that Doug did not really understand what was going on at this hearing, and Ms. Benefield was even chastised by the court for manipulating that system.
Well, thank
and
you
so-
for adding that. Let me just ask you a question. What is it about you may not contact Miss Benefield that you think Doug didn't understand? By the way, Doug was there and heard the judge say it. So enlighten us, please. What do you think it was about you may not contact Miss Benefield that Doug would not have understood?
Doug did not have the court order when he went to buy her birthday present. He told me that the negotiations about this mutual restraining order took place in the hallway outside of the courtroom. But I wasn't
But he
there, so that's just
told
what
you.
I was told. And we had the time that he received this order from the judge.
Like, you think that's gonna hold up, girlfriend? Like, that's what he told me, so I believed him. Like, what? I just took his word for it. Are you? And I like how, like, you can tell, like, Doug definitely did a number on her brain because the way she is batting so hard for him, and it's not even just to, like, keep intact her credibility and, like, her reputation. It's because there's some weird, like, I don't know, personal, emotional attachment towards him. But that's what he told me. I wasn't there. You are a lawyer, ma'am. You're his lawyer. Can't you go and seek the documents? Wouldn't you be pissed at your client and say, dude, what the heck? Like, I'm trying to work with you. I'm trying to make things happen for you. You gotta be honest with me. I gotta get these documents now. Are you kidding me? That's what he told me. I gotta backtrack that. That is absolutely insane to me. And I love his line of questioning too, because he's like, what about don't make contact? Does he not understand? As a grown man of what, 54, 55, however old he was, what do you not understand about, hey, You have a restraining order against you. You cannot contact her within, I think it was for 6 months, they said. For 6 months, you cannot make contact with her. That's why he hired the attorney, and she wouldn't say, "That's not why I emailed Ashley on his behalf," even though that is the reason, because he couldn't. So you were fully aware. You were fully aware of the situation. 100% aware. And if you weren't, and now you're talking about how Ashley's manipulating the system, I mean, it's just, my God, if anybody was manipulated, it was you.
Order was signed, but after the hearing took place in South Carolina.
Okay, so after the judge ordered no contact, he sent her a package.
My understanding is that Doug did not really understand what was going on at this hearing, and Ms. Benefield was even chastised by the court for manipulating that system.
Well, thank
and
you
so-
for adding that. Let me just ask you a question. What is it about you may not contact Ms. Benefield that you think Doug didn't understand? By the way, Doug was there and heard the judge say it. So enlighten us, please. What do you think it was about you may not contact Ms. Benefield that Doug would not have understood?
Doug did not have the court order when he went to buy her birthday present. He told me that the negotiations about this mutual restraining order took place in the hallway outside of the courtroom. But I wasn't there, so that's just what I was told. And we had the time that he received this order from the judge, from his attorney's office, and it was after he sent the package.
Okay, so this report by Broder.
So she's saying he bought the gift and the order didn't take place until after he conveniently sent the package already. Okay.
Broder, the one that you acknowledge and the state suggests is the theory behind the homicide. Ms. Benefield had signed a voluntary agreement to participate in that evaluation, correct? It was not court ordered. Isn't that what you told us?
It was not court ordered in the family law court.
So
I don't
she
know what she signed.
She voluntarily participated.
I don't know. You're going to have to talk to the Manatee County Sheriff's Office because it came out of that office or the CPT office.
Well, you were the lawyer for Mr. Benefield. Was your client ordered to participate?
I don't know that we're in agreement with the word ordered. So when I think of an order, I think that a judge has ordered people to do something. And so we had filed a motion for a psychological evaluation in the family law court. And so if that judge had signed the order, that would have been an order. So my answer is I don't know if either of them were ordered to participate.
You're not aware of any commandment that either Mr. Benefield or Ms. Benefield participate in Dr. Broder's evaluation.
It's my understanding that they were both required to as part of the investigation with the Manatee County Sheriff's Department.
Give me just a minute, Ron.
Yes, sir.
She is getting so frazzled.
Are you asking for a moment?
Yes. Same document, actually.
Oh, the same one from before.
On your position that
You notice too, during that little break there, she's no longer smiling at the jury. She seems a little bit more frazzled by this line of questioning because he caught her a couple times and gave her a couple of good jabs.
does that document have any impact on your position that the release of Dr. Broder's report was scheduled for September 30th?
It was scheduled for September 30th. We knew before the weekend that the hearing on the 30th was going to address the joint motion to release the psychological evaluations. Ms. Brown and I had extensive discussions about that because Ms. Benefield was agreeing to dismiss her petition.
Ms. Murphy, I'm sorry to cut you off. Is the answer to my question no, that it doesn't change your position?
It does not change my position. It was scheduled for the 30th.
Well, when we say scheduled for the 30th, is it not a fact that the only hearing that was to take place on the 30th was everything other than Dr. Broder's report?
If you
Is the answer to my, well, let's get a simple answer. Is the answer to that yes?
I don't have the docket, so I guess the answer is I don't know what the docket says. All I know is
You
it was
do not
scheduled for the
know.
30th.
Objection, Judge Leonard, answer the question.
Trying to make sure.
All I know is that was supposed to be addressed on the 30th of September.
And were you not told on the 30th of September that the only issue that would be heard was the
Objection
domestic,
asked and answered.
domestic violence injunction? That's what I'm asking you. Is the answer to that yes or no?
Initially, that was what we were told. That was not the case by the time we got to mediation. The situation had changed.
And do you have any documents that you brought here today to support your contention and the state's theory that the release of this report was the incentive for Miss Benefield to kill Douglas Benefield? Do you have any documents that show that that correspondence with the court's judicial assistant was wrong, and
Objection,
that
compound question.
the only matter being heard was
Objection,
not,
compound
Let me
question.
finish.
was not the domestic violence injunction.
Sustained.
You have anything that supports that the release of Dr. Broder's report was scheduled for the 30th?
I don't know what documents you got from Ms. O'Donnell's office. However, I did provide
Do you
emails.
have any documents here today?
I didn't bring anything, nor was I asked to.
Okay,
You should
so
have
you
the
knew,
emails.
wait, you knew you were coming to court to testify before the jury in a homicide case,
Objection, badgering.
Go ahead and answer your question.
that the incentive for Ms. Benefield to kill her husband was the release of this report on the 30th. You don't have anything to support that, other than what you've told us?
Sustained.
That's all.
Don't, sir, you have one more paper. Mr. Taylor, don't forget your paper.
Damn. That was spicy AF, wasn't it, guys? I mean, I really think he took full control of that. And even though that objection was sustained at the end, and the jury's technically not supposed to consider it, they still heard it. They can still see Stephanie Murphy on the stand getting a little frazzled. I can definitely see all of that, all the reactions. And I like how he keeps driving in the point that this is the theory the state has. This report, and if this is wrong and you don't got the receipts to back this up, because he's got the receipts and we're gonna see those receipts later on. But you can see she's trying to lawyer him. She's trying to lawyer his lawyering. So that was really interesting to see. I've never seen like lawyer on lawyer at like a trial. So it was really, really interesting to see. But let me know what you guys think. What did you think of her testimony? Do you think she's credible? Do you think the defense kind of won in their cross-examination of this witness? Do you think the state won? Let me know either way. Do you think this witness helped prove the state's case in their theory to proving intent?
I'd like to approach also. After the witness.
All right, redirect.
I think there's a short redirect
No
on this.
questions, thank you.
Oh
Can
no.
this witness be released?
Absolutely not. She's under our subpoena.
All right. Yeah, we remain under subpoena. As I said before, same rules on,
That was a hard no from the defense. Absolutely not. We're gonna freaking call her again, and they will, and they 100% will, especially after Faith Brown was testified earlier today. So 100%. And that was ridiculous. That was insane. But now we're gonna skip ahead to Detective Chris Gilliam, and this man is equally as frustrating as this witness for me, just in the way that he talks about how he handles DV victims. And he's the lead detective in this investigation, working in a DV unit. Like that's his specialty. He deals with these types of cases specifically, and the way that he talks about Ashley, the way that he characterizes her is just really gross. Not Michael Proctor level gross, but it's definitely on that definitely like the same. He also kind of looks like Brian Tully, not to be like, oh my god, you look like Tully and therefore I do not like you, but he just gives like really gross bad vibes. In my opinion, the way that he talks about DV victims and how he specifically treated Ashley's allegations and how she would be, I don't know if he used the word badgering, but she would call him up a lot and she just seemed hysterical, and he ultimately just didn't believe anything that she was saying, even though she was trying to report all these different instances and seemingly trying to take the right steps, in my opinion, to do whatever she could to successfully just get Doug away from her, protect herself, protect her baby, and just move on with her life. It seems like she tried to take as much legal action into her hand as possible. So we're going to zoom ahead to a little bit of his testimony, and then we will get into Dr. Broder's testimony a little bit as well too. That was what they spent essentially the last 20 minutes or so of Stephanie Murphy's testimony. So it's really important we get to that and what was in the report. And then we'll round things off with Dr. Quintel, who is the other psychologist. I think that not the court ordered, but that I think the two of them, it was recommended, I guess, that they speak to Dr. Quintel. So I caught like some of his testimony. So some of this I'm gonna kind of be reacting to in real time. But Dr. Gilliam's testimony was Detective, excuse me, Gilliam's testimony was extreme.
She was wanting to know the status of the case and when Doug would be getting arrested for the violation of the injunction.
Okay. And when injunctions and that type of thing.
I certainly have.
Okay. Now, sometimes when someone is asking for an injunction, or when an injunction is violated, it can be charged criminally, correct?
Correct.
Okay. Or they can take other avenues
That's
to address the violation.
So they're specifically talking to, and I just wanted to kind of like skip through a little bit of like his background stuff, etc. But they're talking about the injunction from South Carolina, the restraining order that Ashley had against Doug, and if there was a way for her to get that I guess not even reinstated, but to enforce that in Florida, because that was in South Carolina.
But you're not involved in that other avenue if it's a different court, correct?
Yes, I'm not involved in that.
All right. Did you become familiar at some point with someone named Ashley Benefield?
I did.
And when was that?
December of 2017.
Okay. Generally, what were the circumstances without getting into a lot of detail?
She reported that her husband violated an injunction that was in place out of South Carolina.
Okay. And that came to you?
Correct.
Right. And we've heard several mentionings of poisoning. Did this have to do with the same issue?
It was the same case, yes, but I had nothing to do with that investigation.
Okay. So the poisoning itself, you didn't have any contact with. It was just the violation of injunction.
Correct.
Okay. Did you speak to Ashley?
I did.
How many times would you say you spoke to Ashley?
I think a fair number would be 30 to 40.
Okay. And generally speaking, was that because you were contacting her or she was contacting you?
No, she started contacting me on a regular basis beginning around February of 2018.
Okay. And what was she contacting you about?
She was wanting to know the status of the case and when Doug would be getting arrested for the violation of the injunction.
Okay. And when you do a violation of injunction, when you're investigating a violation of injunction, you can do several things, correct? You can, explain what you can do with it.
We can make a physical arrest in the case. There could be no charges filed in the case, or we can send the case to the state attorney's office.
Okay. So if you send the case to the state attorney's office, what does that mean?
We're just letting them make the ultimate decision if they think there's enough charges to be filed in this case.
Okay. So it sounds like there's no charges and then arrest. And
Sustained.
so you said Ms. Benefield was calling you asking about the arrest of Mr. Benefield.
Yes.
Okay. And what did you tell her?
That the case was still suspended at that point, and when I had an answer for her, I would let her know.
Okay. And so that was the beginning of your conversations.
Yes.
Right? So did she continue to call
Yes, repeatedly, twice a week at least.
and speak to you personally?
Yes.
And what was her comments? What were her concerns?
It was the same thing. When was Doug going to be arrested for violating the injunction?
Had you ever told her that he was going to be arrested?
I did not.
At some point, did you decide to forward the charges?
I did.
And is that to the state attorney's office like we talked about?
Yes, it is.
Okay. Did you inform her of that?
I sure did.
Okay. And what was her reaction to that?
She was upset that he was not being arrested.
Okay. Were you able to explain to her that the process and how this was going to go?
Sustained.
Were you able to explain the process to her?
Yes, I was.
Okay. And how did she take that?
She was not happy that I was not placing Doug under arrest.
Okay.
Obviously.
At some point, did you speak to Ashley Benefield again? And she told you about a court hearing?
Yes.
Okay. Approximately when was that conversation?
Around the first week of May 2018.
May 2018. And what did she say?
She just got right into the phone call and requested that I arrest Doug for a hearing that was coming up in Manatee.
So again, just to recap, he is the detective for the violation of the injunction that was filed, the restraining order filed in South Carolina. So not the homicide, not Doug's murder, but Doug's violation of the South Carolina restraining order. I know there's like a lot of detectives and stuff that testified in an earlier testimony, but this is not that detective.
County.
Okay, you just said arrest for a hearing.
Yes.
But arrest at a hearing?
Yes, there was a upcoming hearing in Manatee County.
Okay. And was that hearing involving your case or something else?
It was something else. It was not my case.
Okay. Did you know that there was a hearing or there was even a court issue going on?
I did not.
So she told you there was a court hearing, and did she tell you when it was?
No, that just shows there was an upcoming hearing, and she asked for me to arrest Doug when he came inside the courtroom in front of the presiding judge.
Okay. And what was your reaction to that?
That absolutely would not occur.
Okay. And how did she take that?
She was upset. And at that point, I would call it a dramatic cry, hysterical cry started happening. And I'm still informing her, we're not going to do that. We're just not going to arrest him in the courtroom. And she made a comment, something to the effect of, if the judge sees you arrest him, this will help me keep my baby. So I thought that was a pretty bold statement. And I'm like, I'm still trying to give her the benefit of the doubt. She just gave birth. Maybe she's confused. And I'm trying to explain to her gently, that's just not going to happen, especially not going to happen for a judge to see to help you in a civil matter.
And did you in fact explain all that to her?
Yes, I did.
And how did she react?
We went back and forth 5 minutes or so. Her just kept requesting to arrest him. I said, this is not going to happen. And her tone turned from the crying to very aggressive. And she says, you will effing arrest him in front of the judge and I will make sure you do it.
What did you say to that?
I started pushing back a little bit and I said, it's not going to happen. Whatever you say or do, you cannot make me arrest somebody in front of a judge. And it's just not going to happen.
And what did she do?
I guess she started crying again and came out with a comment, something like of, I can't believe you're willing to allow Doug to kill me and the baby.
Okay.
And that hadn't come up in this phone call. The phone call dealt with me arresting Doug in front of a judge. And then it turned to not arresting him, allowing me to let him kill her and the baby.
Okay. So that seemed kind of different to you.
Yes.
Than what you had previously been.
Yes.
Okay. How long did this conversation go on?
Because she's frustrated. Again, like, if we're to believe, and the more and more that like I dig into this, like I do believe Ashley. I do believe that she was afraid of Doug. I mean, he has a history of violent tendencies. It doesn't take a rocket scientist to say it's not possible for him to also express those violent tendencies towards her when there's been a documented history of abuse, not only with just and again, documented history of this behavior. It doesn't always have to be physical. He doesn't need to put hands on her in order for that to justify his DV. But even just showcasing violent behavior, manipulative behavior of firing off the firearm in the house, that has been confirmed. That happened. Him hurting the animals, punching the dog to unconsciousness, throwing the cat, throwing a loaded gun at her. And I can understand she's getting frustrated. She's getting frustrated with this detective and saying, well, why aren't you? And I could see her emotions escalating. And even if she's trying to do it the right way and saying, when are you going to arrest him? Because again, at the end of the day, this is all just from his perspective and what he's willing to share. We don't know exactly. We haven't heard like any kind of recording of a phone call or anything like that. No transcripts, nothing like that. This is all just based off of his word. So take that, make that what you will, but regardless. But I can totally see her saying like, nobody is believing me. Like, if you do this in front of the judge, then somebody will take me seriously. And I don't know. I don't know if I missed this before. You guys let me know if you caught on to anything. But he said that it was pending. Like the case was pending, and that he couldn't like arrest Doug. And I don't know why. Like, is that explained? Why was it pending? Why isn't it just like, hey, he's in violation of this. Like, this was ordered in South Carolina. Can't you just like make a frickin' phone call? I don't know. Again, I don't know how it works. I don't know how the process works. It seems very vague from what he's testifying to. And I don't know if he can get into all the ins and outs. I know there were a couple of objections that were sustained. So I don't know what that looks like. But I just feel like, and I've had a restraining order filed when I was a child. I was a victim of YouTube won't let me say the word, but of rooming with a G. And I had a restraining order. I think it was or an order of protection rather, for 5 years, and then it expired against the person who hurt me, and it So I can only imagine if I had moved out of state for whatever reason with my family, and God forbid this person had followed me, I would want that order of protection there to protect me. That's what they're there for. And I don't, again, I don't know how the law works from state to state, but I feel like if you get a restraining order in one state, it should carry over into any state because it's still against the same person. And if it's within the same time frame. So I don't know what the deal with this is, why it was a problem.
20 to 30 minutes
Okay.
for up to that time. It's probably 20 to 30 minutes.
Okay. And during this time, excuse me, did the defendant ever seem to understand the process of what you were saying?
No,
And at some point, did she change from crying again?
she did.
What did she do?
It just abruptly changed, and she let out like a screech or a high-pitched scream. And she says, "I'll do whatever I have to do to kill my baby, or keep my baby, you a-hole."
Okay. So it's a high-pitched scream, or did you say scream or screech?
Like a screech at first, but it was I'll call it a screech.
A screech.
Yeah.
And tell me, what volume is this?
I could just say it's a very loud, maybe top of lung type scream.
Okay. Could you demonstrate to us?
It's impossible. There's no way I could.
Why would it be impossible?
I couldn't get my voice that high. There's no way.
So
There's no way. Like, he just seems so cold too. Like, he does seem like an a-hole. And I like, not somebody that I would feel comfortable with going to and saying, feeling safe around. Like, you're not the guy that I would go to report something like this to. 100% no. Like, it seems like you don't give a fuck. Like, you do not care. You don't care. You're there to collect a paycheck, fine, whatever, if that's your thing, but you're in the wrong unit, buddy. Like, you should be doing like mall cop security or something with, I don't even know. We're like, join the bowling team with that freaking head. Like, but I can understand like the way that they're trying to paint Ashley as, oh, this overly hysterical woman. He's like, oh, well, I tried to give her the benefit of the doubt because she just had a baby. Yeah, she might also be suffering from postpartum. My God, like where your hormones are all over the place. My sister, my niece is now almost 2. Oh my gosh, time flies. Almost 2. And I remember after my sister had a hard time after her pregnancy, struggling with depression, struggling with postpartum, and it was really upsetting to hear about and watch. And she was going to therapy and putting in a lot of really good work for herself to get through that. But I can only imagine, and I've never been pregnant, like, so I don't personally know, but I know from the women in my life who have, and what postpartum depression looks like. I mean, a great example, and this is like a totally different case, but Andrea Yates. Severe, and like also I think she was diagnosed with bipolar disorder too, like, or schizophrenia, other mental illnesses, but she also suffered from postpartum depression. And it's just like an absolutely awful tragedy. That case always just like deeply disturbed me. But it's deeply saddening because so many people still don't take postpartum depression seriously. And again, we don't know. Like, we haven't gone into any of the medical testimony and gone into like, was she suffering from this? And was she, because even if that is the case, you could argue maybe she is feeling a little bit, everything's extra heightened. So the panic that she's already feeling in her day-to-day life from feeling threatened by Doug, maybe she is like, oh my God, what if I am being poisoned? And all of these different emotions and feelings. So I feel like the way that he's just talking about her is just so like, I don't know, icky to me. Like, he doesn't buy what she's saying. And he even says this. He doesn't buy what she's telling him. He doesn't care. He doesn't want to talk to her.
it was loud and it was high.
Yes.
And she said, can you repeat what she said?
I will do anything I have to do to keep my baby, you a-hole.
You a-hole.
And he didn't like that. Like, you could see, like, he's kind of chewing on his lip. Like, don't call me an a-hole. He wants to go Michael Proctor on her. Like, that's the vibe I'm getting here.
And did she say a-hole?
No, she said the full word.
And after she said that, what'd she do?
At that point, I had checked out of the phone call, and I was pretty much ready to hang up the phone on her. And she accused me of conspiring with Doug to get her baby taken away.
And had you even spoken to Doug about custody of the child?
No.
Okay. Were there other detectives around you at the time of this phone call?
I mean, in that moment, it's like if you feel like your life is being in danger and nobody is listening to you, yeah, like it's like what are you all conspiring against me? It just reminds me so much of like that Karen Reed when she's like, "Is this a joke?" Like, and we're all in on this joke. That's the exact vibe that I'm getting from this. Is nobody is like seriously, nobody is believing me. Really? Okay. Like, and yeah, a mother's gonna do whatever she needs to do to protect her kid. And if she feels like you're not taking her seriously and you are being an a-hole, it sounds like, because it sounds like you don't care. You mentally check out of a DV victim. Like, it just sounds like you don't even believe she's any kind of victim. She has a restraining order. Why do you think a judge would grant her a restraining order if they didn't believe there was factual evidence to back that up and support it? Why do you think she's calling you as many times per week as she is? She's trying to seek the help that she needs. And if she really is willing to do whatever she wants, like, wouldn't she have done it sooner? I don't know. Again, all speculation, Breen, but just being me personally and being in similar situations, I can understand. You go from like, like who can I trust? And you just start all these different thoughts start swirling in your head and you start putting together things that may not make sense typically in your day to day. Like, no, would he be conspiring with Doug? Probably not. It just sounds like he doesn't care. He doesn't care. He doesn't want to talk to an hysterical woman, which is just gross. He's like, "Oh, I can't even get my voice that high." Like, it's just so demeaning the way that he's talking about her. And it's just really disgusting,
Yes, there were two other
in my
detectives.
opinion.
And do you recall their names?
Oh, yes, Detective Patricia Hedrick and Detective Brian Moreland.
And did they appear to recognize that you were on a difficult call?
Oh, they did. And at one point, Brian even asked me if I needed some help.
It's the same.
And at some point, how did the phone call end?
Ms. Benefield terminated the phone call.
And you seem to have a good memory of this call.
Yes,
And why do you have a good memory of this call?
because in my 12 years of doing this, I've never had anybody ask me to arrest someone in front of a judge inside of a courtroom. Now, I have had people call me before and say somebody may be appearing in court that I'm looking for so I can arrest them, but I've never had somebody say, wait until he's inside the courtroom in front of the judge.
Thank you. No further questions.
Cross?
Because for me, it feels like that's her last ditch effort to see, are you guys going to finally take me seriously? If I can get somebody to just arrest him. And I get where the state is going with this, because again, she's trying to say that she wanted Doug out of the picture, but she did not want the report that was going to come out in this hearing to come out. And she was going to do whatever she needed to do. That's why she wanted Doug arrested on that specific date. That is what the state is going with. So if you believe that, then that aligns perfectly with the state's theory. But I think this guy is just a total knucklehead.
Just a moment.
The Gillium,
Yep, sir.
do they teach that to you in police academy?
Sure.
I want to ask you a few questions about report writing.
Sure.
Do they teach that to you in police academy?
Sure. Back in 1989, they did, yes.
Okay. It's obviously an important part of police work.
Sure.
How many cases would you say could you average that you handle in a month?
20,
Okay. And over the course of a year, we're talking about
300 close.
So are you familiar with the saying that they give you in police academy, if it's not in the report, it didn't happen?
I've heard that before, yes.
All right. And that's because the report is obviously more reliable than your memory.
I could understand that, yes.
All right. At 20 cases a month, 2.5 years later, you're into like 600 cases. If you got your report, you can refresh your recollection rather than have to recall off the top of your head.
Sure.
Which is why you want to put critical details in your report, because that's what you want to remember.
Correct.
Not necessarily that somebody had on mismatching socks, but that they had something that's significant to the investigation.
Sure.
All right. So your initial involvement, you told us in the case, is speaking with Ashley Benefield on or about May 31st of 2018 regarding the domestic violence injunction in South Carolina.
That wasn't the first time I spoke with her, no. There were several incidents I spoke several times, so yeah.
Did you speak with her on or about the 31st
I
of
was
May?
prior to that,
Okay, about the South Carolina injunction.
yes.
All right. And just to be clear, we're talking about the same thing. there was a court that had issued an injunction in South Carolina, stay away from one another.
Yes, in South Carolina, that is correct, sir.
Okay. Now, at some point, did you bring any of the reports that you wrote with you here today?
I did.
Do you recall how many you wrote?
Supplemental reports, 3 or 4.
Yes. All right. So initially, if I can ask you about the sequence of these events, Ms. Benefield had gone down to the Manatee County Sheriff's Office to complain about a package that she received.
You know, I'm almost wondering too, because this was a mutual injunction, so both of them couldn't contact each other. While Stephanie Murphy was his lawyer, maybe that when they were going through all their litigation, would that have been a reason why Ashley never met or didn't know Stephanie? Because I always found that interesting when she appeared to show up for that first visit with their baby. When Doug met his baby for the first, or his baby. Now she's got me doing it, guys. Their baby, Ashley's baby, Doug's baby, their baby. The first time that he met their baby. If that's the reason why, because they weren't permitted to be near. But again, that doesn't make sense, because in one regard, they're saying that the injunction in Florida wasn't granted. So I'm just curious as to why, unless she wasn't needed for that and everything was kind of done like they didn't. I don't know. Does that make sense? Like, let me know what you guys think, because there was a judge present, like it wasn't like settled or anything outside. So I'm very curious.
Because it came while the South Carolina injunction was in effect.
Yes.
All right. And it would have been Deputy Wesley Weber, to your knowledge, had requested a capias based upon Ms. Benefield's receipt of that package.
Correct.
Just so the ladies and gentlemen of the jury understand, capias is an
Objection.
arrest warrant.
Testimony. And
It's the same.
it's all hearsay.
What is a capias?
A capias is information where a deputy believes that there's probable cause for someone's arrest.
All right. That was issued by Deputy Wesley Weber.
Correct.
And that would have been on December 14th of 2017.
That sounds correct.
Now, a month later, well, actually, several months later, on May 31st of 2018,
Objection, Judge. I called for hearsay, though. I apologize. I wasn't finished the question.
did you write the first of your supplemental reports?
Yes.
And in that report, you stated that Ms. Benefield,
Objection. Hearsay.
It's the same.
in the report, did you indicate,
Objection, hearsay.
It's the same.
did you write anything in your report in describing,
I don't get, how is this hearsay if it's what he wrote in his report? Like I'm just not understanding that. It's what he wrote in a report. So I guess because he doesn't have the report before him and it wasn't entered into evidence. But why would that be hearsay? It's in a report. So
Hearsay.
Can you approach, please?
hold on, let me have one more shot at it. Did you document in your report anything different than you told us here today about how you characterized Ms. Benefield's demeanor?
I didn't go into any details in that supplement at all, in that one.
May I show him the report?
So he has a report. So why, I don't understand how it's hearsay.
Judge Miller.
Yes.
So they're gonna approach. I also find it interesting how he's facing the jury.
During that time, Detective Gilliam, back in May of 2018, you overrode Deputy Wesley Weber's capias request, correct?
I did.
Okay, and you put the case on an inactive status.
Yes.
And I think you decided, as you told us, it would be submitted to the state attorney's office.
That is correct.
Now, on June 5th of 2018,
So there was going to be which is why Ashley probably thought, because of this other detective, probably thought that, yeah, Doug is going to get arrested. And then Gilliam comes in and says, no, 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 I'm going to make this thing inactive. Like, he's not getting arrested. That's the way it sounds to me. So that's probably why she was battering you. According to your words, right? I didn't think he used the word badger, but that's why she was calling you up so much, because she was probably told by this other detective that, yeah, charges are going to be filed. Yes, he is going to be arrested. Okay.
And you interviewed Douglas Benefield, did you not?
Correct.
And he admitted to you.
Objection, hearsay.
Sustained.
What was his position with respect when you asked him,
Objection, hearsay.
Finish the question.
did you send the package to Miss Benefield?
Sustained.
Did you make a determination from your conversation with Mr. Benefield whether or not the package had been sent to Miss Benefield?
Objection, Broder.
Can you ask a question again, please?
Sure. Did you make a determination as a result of your investigation whether a package had been sent to Miss Benefield?
Yes.
Did you make a determination as to who sent it?
Yes.
Who?
Douglas Benefield.
Did you make a determination of what the contents of the package were?
It was a T set.
And was hazmat called?
Objection, Judge. Hearsay.
Sustained.
As part,
Did you say hazmat?
yes, sir. As part of your investigation, did you make any determination whether or not there was a response by
Objection, hearsay.
any other agency to this package that was sent to Miss Benefield?
Objection, hearsay.
Sustained.
Did you tell Mr. Benefield that you would be able to unfound the case if he sent you the receipt?
Objection, hearsay.
I'm asking him
Mhm.
if he told Mr. Benefield.
Can you please approach?
Did you tell Mr.
Can
Benefield?
you please approach? Can you please approach
Oh.
the bench?
Sorry.
So they're going to approach again. A lot of objection overrule on hearsay.
Douglas Benefield, you could unfound. I think the last question I asked you was, did you tell
No,
Douglas Benefield you
Ben
could
wins that
unfound the
one.
case if he sent you the receipt for the sending of this package of tea?
No.
So did you write a supplemental report as a result of this interview with Mr. Benefield?
Yes.
And this would have been on June 5th of 2018.
That's correct.
Now, did you put and document in that report anything about Miss Benefield?
I would have to look. If you don't mind, I can certainly.
Please.
No, I don't see anything about Ms. Benefield in this supplement. No, I don't see anything about Ms. Benefield in this supplement.
Okay, you did determine though that the package, once you got the receipt, you determined the date the package was sent.
Yes.
And that was on when?
November 27th, which is when the injunction was signed off on by the judge. It was the
Yeah.
same day.
But you also determined that the hearing on the injunction was November 3rd,
That
2007.
was the hearing, but the judge did not sign off on this until the 27th, which was the same day. So,
Right. But at the hearing, Mr. Benefield was present when the judge announced.
yes, when he announced, but it was
Okay.
my understanding it's not in effect until the judge granted his signature on the 27th, which is the same day that Mr. Benefield sent out that T-set.
Okay, who is the lead detective in this case,
For which case?
for the homicide case?
I'm not sure.
Is it Detective Warren?
I don't know.
Do you recall contacting Detective Warren on November 30th, 2020 at 7:47 a.m.?
I do remember contacting him. I'm not sure if that's the date, but yes, I did.
Okay, and do you now recall that Detective Warren is the lead homicide investigator?
I'm not sure if he was the lead. I know that he was at that scene, but I'm not sure if he's the lead investigator.
Okay, so you talked to Detective Warren on that day.
Yes.
You then, 16 days later, Detective wrote another supplementary report, correct?
I'm not sure if it was 16 days later. I would have to.
Why don't you take a look and
Sure.
see if that report isn't 16 days.
So if I'm understanding things correctly, his testimony lined up with what Stephanie Murphy said about the T set was sent, I guess was sent the same day that that injunction was signed on the 27th, and then there was that hearing on, I think they said November 3rd, if I'm remembering correctly. But now they're talking about reporting and writing misinformation and or leaving out certain things in reports, which we are all too familiar with from the Karen Reed case.
Following your contact with Detective Warren.
And when did you say I contacted Detective Warren?
You contacted Detective.
I also like how he's like, I didn't know he was the lead investigator. And then he's like, well, didn't you contact him? And he's like, well, I knew he was at the scene. Why would you be randomly contacting him? Like, I don't know. Maybe you guys are buddies. But I just find that also ironic. I don't know who he is, but I didn't know who the lead investigator was, but I contacted him.
On September
Yeah.
30th,
Knew he was
2020
on the
at
scene.
7:47 a.m.
Yes, I entered a supplement on October 15th, 2020.
Okay. Now, following your conversation with Detective Warren on that day, September 30th, 2020 at 7:47 a.m. in the morning, you write a third supplement, do you not?
Correct.
And it's dated October 15th, 2020,
That is correct.
16 days after speaking with Detective Warren.
That is correct.
In that supplement, you list, do you not, the details of what you described today about how Ms. Benefield behaved.
That's correct.
So let's make sure we understand this now. This is 2.5 years following the discussion that you related to the ladies and gentlemen of the jury of Ms. Benefield's response. 2.5 years later, you remember the details of the conversation
Absolutely.
and exactly what she said. Quotes, you quote her.
Yes.
But you never mention one word of it in your supplement that you wrote on June 5th of 2018.
You are absolutely correct.
Nothing further. Let me just check.
Mic drop. So he didn't mention anything about, I guess, Ashley calling him an a-hole. I'm going to do whatever I need to do to keep my baby safe. That whole comment that he specifically recalls her saying. I don't know if he's also Mr. Taylor's referring to the fact that she asked him to arrest Doug in court, if that was also missing from the supplemental report, but that is freaking huge. That is freaking huge. If a lot of that information wasn't disclosed, and if so, why? What's the purpose of hiding? Why are you hiding?
Okay, that's all. Thank you.
Redirect.
Why didn't you add that information to your supplement back in 2018?
In my initial supplement, which was May 31st, I did put in that supplement that she demanded an arrest be made in the courtroom when he appeared. At the time of my interaction with her, I didn't see anything she said at that time as a direct threat to Doug. It had no relevance to my case. I saw this as her just having this massive meltdown because she wasn't getting her way with me. So at that point, it was just not relevant for my case. There was no reason, but circumstances have changed. I thought that's information that needed to be heard.
Okay. So, and what circumstances?
Circumstances have been changed, so therefore I just input this magically. I decided it was important to finally share this because it fits the narrative. It fits the state's narrative. We've seen this so many time and time again, where certain things aren't put in reports and then they end up in reports later on. And then suddenly witness testimony has been revised over like 6 or 7 times from the original report. So now he's going to tell us why.
Obviously, Mr. Benefield is deceased at this time. And her words at that time may have had an entirely different meaning. I did not take it as a threat. I took her saying, I'll do whatever I have to do to keep my baby, you a-hole, as my manipulation attempt for the court system. Not that she was going to create any harm to Mr. Benefield. Now, she never mentioned anything like that. She was never any threats. But I just took that as a manipulation attempt. When she wasn't getting her way with me, it was a meltdown. And there was just no reason for me to put that in my supplement that she was having this massive meltdown because I wasn't going to buy into it.
What? Because it would make you look good if you said that, you a-hole, and you are an a-hole, and she's 100% correct in calling you an a-hole, because you are. You're in the wrong unit, buddy. This is so frustrating about this witness too, is like he's kind of like a mini version of Michael Proctor. Like all you're missing is your text thread with your buddies. That's all you're missing. And I wonder, maybe he does have a text thread. Who knows? Speculation brain. But wow. And you see how like kind of like defensive he gets too, because he's like, he's got to now explain like why he didn't include that in his supplemental report. But it also helps the defense too, because he's saying, no, she never said anything threatening about Doug. Never said she was going to do anything to hurt Doug. So he also denies that as well. No, she never said that. I just thought she was going to manipulate the court because she wasn't having her way with me. Which is just like a gross comment to make. Like, you are in the wrong. I wonder how many, I feel so bad for any DV victim that has to like, or survivor whose case is assigned to this schmuck.
And so after she murders Doug Benefield, you thought it was relevant,
I thought that was very relevant information that needed to be heard.
And did you reach out to someone about that?
I did.
Or did they reach out to you?
I reached out to him.
You reached out to Detective Warren,
Yes.
correct? Okay. Thank you. No further questions.
The detective
Who you didn't know was the lead investigator. Like, come on now, buddy.
wanted the director to write this up.
Absolutely not. I wouldn't take orders from him to begin with.
And 2.5 years later, you remember that she said specific things. This will help me keep my baby if the judge sees you arrested, quote unquote.
Yes, because it's a very, very bizarre comment I've never heard before in my career.
That's like 600 something cases later.
That's fair.
That's all.
Okay, can you be released from the subpoena?
Yes.
So you're released from the subpoena, you're free to go.
Thank you, sir.
Oh, no, I'm sorry. Of course. Sorry.
Detective Gilliam. Hold on. Sir, you have not been released from your subpoena. The rule of sequestration has been invoked by the
Good, call him back. Ugh, what a schmuck. It's just like so, ugh. He's like, oh, because now he's dead. Now let me just, oh, by the way, I happen to recall, like, this just reeks of, like, the Karen Reed investigation. Does it not, guys? Does it not? Like, I didn't know he was the lead investigator on this case. But I knew he was on the scene. Why wouldn't you call the lead investigator then? Like, if you didn't think he was the one on the scene, or wouldn't you ask him, like, hey? And how would you know? Like, so many questions. So that was Detective Gilliam. Now we're going to get into Dr. Broder on cross. And then we're going to do a little bit of Dr. Quintel. His testimony is a little bit shorter.
Good afternoon.
Good afternoon, sir.
We've met before.
Yes, sir.
Your history in this case has,
He's going to go a little bit into the history, but again, just to recap. So this is what a lot of Stephanie Murphy's testimony was about, was whether or not this report was going to be entered in at that hearing. Who better to ask than the man himself? Were you on vacation? We wanted to know. Were you on vacation during this hearing when it was scheduled?
wound its way through to where we are today, and it's encompassed prior proceedings, has it not?
Yes. Yes.
Okay. And you've had occasion to sit for a deposition in this case,
Yes, correct.
and you've also given previous testimony.
Twice before in the
All right.
dependency
Don't
case.
tell me where.
Okay.
So you've told us that Ashley would act one way when she was with you, but she would act differently when she was with Doug. Correct?
Yes, that's correct.
All right. And your conclusion that you reached was that she would appease Doug. Was that not the case?
Ashley had shared with me a number of times that she felt the best way to keep Doug at bay so he wouldn't hurt Emerson was to kind of appease him, to kind of go along with him.
Yes. In your words, I believe in your report, go along, get along.
I believe that's correct.
Correct?
Yes.
And that would be especially the case when Emerson was involved.
Yes.
All right. So for example, if she didn't particularly want to be in,
So they approach. But what's interesting too, because I think Stephanie Murphy testified to this, is that Ashley knew this report was coming in. So like if she she agreed, not only that she knew, obviously she knew, but that she agreed to this report coming in. Like both parties were mutually agreed on this report coming in. So I don't see why this would be the big be and end all for motive. It's just really weak, in my opinion. It's really weak, and I feel like as we get into further into future testimony as well too, just especially too when because Ashley ends up, spoiler alert, Ashley ends up taking the stand on day 4, and it's just like some of the most egregious stuff I've ever seen in my life, like completely triggering to a whole new level. But they go into a little bit about what was in this report, what she said to, or what she, I believe, like what she talked about with Dr. Moreland, etc.
so I think you told us, Dr. Broder, that
Dr.
this
Broder,
policy
sorry.
of appeasement was designed by Ms. Benefield to basically placate Doug Benefield.
I think I would use the word strategy. That was her idea of trying to.
Yes, to placate him. In other words, to not set him off.
She knew that he wanted to reconcile, so she wanted to kind of, I think, feed into that, so he wouldn't, given her belief that he might hurt Emerson.
Okay. And you, did you decide whether or not the signs were there, but that Doug Benefield refused to recognize them? That she wanted no part of a marriage to him?
Let me make sure I understand the question. Are you saying, did I discuss with him about the signs?
No, did you acknowledge during the course of these evaluations that the signs were there, that Ms. Benefield did not want to be in this relationship with Doug Benefield, but he misinterpreted them and insisted on trying to be with her?
Unlike therapy and evaluation, you're constantly generating hypotheses, meaning asking other questions to make an assessment of the overall situation, different than a therapeutic relationship where you might be making interpretive statements and recommendations.
Let me ask you this. Did you consider that Ashley's position was that Doug was only interested in her and not in the child?
I certainly considered that, yes.
And that was Ms. Benefield's position, was it not?
That his sole aim was to win her back, yes.
The abuse complaints, without giving me names,
Mhm.
they were initiated by more than the same person, correct?
Correct.
In fact, there was,
Objection, your second.
Finish your question.
in fact, there was at least 3 different sources,
I'll overrule. Go ahead.
I believe there were 3, correct.
and 2 of those sources were professionals.
Sustained.
She expressed to you that she not real frustration with the system and its responsiveness to her situation.
Yes, she did. She was very forthright.
And she told you that with respect to taking matters into her own hands, it was going to be by virtue of her going to Maryland and petitioning the authorities there.
My concern was that she was going to impulsively abscond with the child and go to Maryland and, yes, establish residence separate and apart from Doug.
Okay, that she would have access to the authorities there, that they might be more responsive.
That was her hope, her goal, yes.
All right. Are you familiar in your practice with domestic violence?
Yes.
Have you treated it before?
I assessed it and treated it on occasion, yes.
Did Douglas Benefield, from what you learned as a result of your involvement in this case, exhibit
Objection.
Go and finish your question.
symptoms consistent with the domestic violence abuser?
Sustained.
Give me a minute, Your Honor.
So he's figuring out what he wants to ask
Well, what-
next.
did you find that Ashley Benefield had any impulse or was prone to angry outbursts?
Well, that's two different things, impulsivity and angry outbursts. I did not find her to be having angry outbursts, no.
You in fact concluded she was a good mother.
Yes, I observed her many times.
That's all.
We'd like to keep Dr. Broder on this.
Redirect.
You're familiar with mandatory reporting laws, right?
Yes, ma'am.
And what does that mean, mandatory reporter?
The mere suspicion of any kind of abuse towards a child or an elder, as well as domestic violence, that needs to be reported.
So if someone goes to their child's pediatrician, or someone comes to you as a doctor and alleges abuse, what would you have to do?
I would have to report it.
Thank you. No further questions.
All right, doctor, at this point, we're done asking questions. However, as you've heard, you remain under subpoena. The rule of sequestration has been invoked in this case by the parties, so that means
So he's going to get probably recalled again. But it seemed like from even Dr. Schmuck before, I keep calling him a dang doctor. He is not a doctor. Detective Schmuck even testified that no, she never expressed that she was going to take matter into her own hands, meaning like she was going to end Doug's life and unalive him. But no, she was going to do what she said. Go to Maryland, see if she could take it up with the courts there, because Florida's clearly not giving her a fair shot. Nobody's saying, there's been no evidence thus far proving that Ashley had any kind of violent tendencies. And the only allegations of somebody displaying violent behavior is Doug. That is the only person. Now, that being said, in that particular moment, when she did unalive him, did she feel like her personal safety was at risk? Let's see. Because that is undoubtedly what the state has to prove. All of this, them trying to prove some kind of motive, I mean, it's just really weak, in my opinion. I mean, nothing from what I can see. Maybe you guys have a different perspective from his report. Seems especially damning to her. If anything, it just expresses further everything that we already know up until now, is that, yeah, she was afraid of Doug. She was afraid of him. She wanted to protect her child. She was a good mother. She acted differently when she was alone and when she was with Doug, which makes so much sense. Because I know exactly how I used to behave when I was around that person in my life and when I wasn't. And people around me noticed. My family noticed. I was a totally different person. I remember one time we had gone to like a screening of a movie I was in the city. We walked back to Penn Station. He's all aggravated because we missed a couple blocks and we walked a little bit further than we normally would. So he was already agitated. Me and my family, my friends who came out to support me, we were going back to Long Island to take a train back. That's where we all lived. He did not live there. He lived in a different state. We were going two separate ways. So my family was like, hey, it's going to be a minute before we get on the train. Let's all get dinner. Now I'm directly inviting him. We're not inviting him, but we figured, hey, we're all going separate ways. He put up a big fight, got into an argument with my parents. He ran downstairs to go to his train platform. And I chased after him. Like I left my family and my friends and I chased after him. And after all is said and done, because I ended up riding back with my friends and my family went ahead without us, they like sat me down. They're like, this is absolutely insane. Like just the control and the manipulation. Like I have never done that in my life. And you become a totally different person when you are around these people. A totally different person than when you are one-on-one. And sometimes it takes other people to see it for you to start believing it and realizing it. And I think it was good that she had an outside perspective confirming exactly what the evidence has been presented all along, is that, yeah, she was afraid of him. She was trying to go to Maryland. There was nothing, no house long till I can unalive my husband and go to Maryland. No Google searches. Jen McCabe. No butt dials. No going to Walmart and buying nefarious supplies. No talking about it with other people. Nothing. Nothing. Nothing to indicate that that is what she wanted. And the more and more that we get through testimony, the more and more I believe that Ashley is being honest. That she was in fear for her life in that moment. And I don't think she intended for things to go down the way that they did. But she felt so trapped. And in that moment, maybe she felt it was either her or him. And she just wanted it all to stop. And I completely understand that. So I don't see how this particular testimony or what was in this report, what wasn't in this report, was especially damning for Ashley. So now we're gonna end things off with Dr. Jason Quintel.
So we heard from Dr. Broder. He was talking about his goal was to do an evaluation. What was your goal with meeting with them? Was it an evaluation or something else?
No, I was referred by another therapist to do trauma resolution treatment for both Doug and.
So he's doing trauma resolution treatment after Dr. Broder had met with them. This is for both Doug and Ashley, not just Ashley, not just Doug, but for both of them.
And Ashley?
Okay. And as part of that, did you meet with them together as well as separate, or how did that work?
I did. I met with them originally as a couple. We ended the treatment as a couple, and then there were individual sessions in between.
Okay. I won't hold you to this, but about how many times did you see them?
So I met with Doug twice individually, Ashley 5 times individually, both of them as a couple twice. There was a total of 4 hours for couples, 10.5 hours for Ashley, and 4.5 hours for Doug.
Okay. And at the first session, did it seem to you as though, let me back up. The first session, was it together?
Yes, it was.
Okay. And during that first session, did it seem as though they wanted to work things out?
During the first session, they talked about, yes, they wanted to work things out.
Okay. When they were together, did they indicate they wanted to get back together, like reunify?
The goal was for them to reunify and moving to Maryland.
Okay. When Ashley met with you by herself, did she still make that representation?
That they were moving to Maryland, yes.
Okay. And was there anything different about her representation?
Ashley was different when she was separate from Doug in terms of more descriptive of things that had happened between the two of them that troubled her. So some stuff that was scary.
And we won't get into specifics, but
That's the question. He's entitled to complete his answer.
so did she indicate she still wanted to reconcile with him when she was with you alone? Did she say she wanted to reconcile with him when she was alone with you?
So I don't recall whether she said she wanted to reconcile with him or not. I think that there were challenges in their marriage and she was questioning whether she wanted to be with him or not.
Okay. Did Ashley tell you that she and Doug were also seeing Dr. Broder?
They both mentioned that Dr. Broder was doing an evaluation and I didn't know what it was regarding.
Okay. And did Ashley say to you at any time that she was frustrated with the system?
I think Ashley was discouraged. There had been many things brought up, accusations, CPS, judge, that didn't go her way. So I think there was definitely some discouragement with that.
Okay.
And
I'm sorry to cut you off.
no, you're fine.
Did she express any frustration at the time it was taking for Dr. Broder's report?
Yeah, she thought that that was taking a very long time.
Okay. And did she express to you that she was worried about what his report would say or worried about when the report was released?
She was worried about what it would say. She said if it were to be disparaging of Doug, she was concerned that he would be upset and take some form of retribution with that.
Okay. The last time that you saw them was when?
The last visit was on 9/25/20.
Do you remember what day of the week that was? You might not, but
Maybe Thursday, Friday. I can look if you need that.
no, that's okay.
Okay.
And about what time of day was it?
I believe
He brings notes. Stephanie. He brings stuff. He brings the receipts to court. Stephanie.
That was a morning session, 10:30-ish.
Did they say Dr. Broder's report was done?
I don't recall them saying that the report was done. I know that they had been waiting on it, and it was supposed to determine specific things for how they move forward.
Okay. And did they,
So then what date was this again? Let's just get the
day
date.
was it?
I believe that was a morning session, 10:30-ish.
Okay. Did they say Dr. Broder's report was done?
30.
No, when?
The last visit was on 9/25/20.
9/25/20.
I don't recall
Doug. Oh, so is it? Oh, snap. So this is 2 days before? Okay.
them saying that the report was done. I know that they had been waiting on it, and it was supposed to determine specific things for how they move forward.
Okay. And did they indicate when they were going to court next?
I do not know that. I don't recall anything mentioned
Okay.
about when court was.
Did they
They're trying
indicate
to
to you
get
when they
him-
expected they were going to have access to that report? Excuse me.
No, I don't. There was not a when the report was going to be released. It was going to happen at some point.
Okay.
My understanding.
So the prosecution is trying to get him to say the magic words on 9/30, 3 days after Doug was murdered.
Is that they still had plans to move to Maryland.
Thank you. I have no further questions.
Okay.
Cross.
Afternoon, Dr. Quintel.
Hi.
How are you?
I'm doing fine. How are you?
Good. So tell us why, when you met with them, Ashley was different when she was alone and when she was together with Doug in meeting with you.
So Ashley presented that she was concerned about Doug. There was prior acts of violence, shooting a gun. No.
Sustained.
Okay, without? Yeah. Oh, you have no idea. Without?
Why don't you go ahead, excuse me, Deputy, would you please go ahead and take the jury out? Remember, please don't begin your deliberations. You can't use your phones, but don't talk.
So the judge reacts real quick to that, and I actually totally forgot about this, but the judge gives him a major verbal spanking. Probably like more so. Like now that I'm rewatching this again, I'm like, I feel like I don't know. It's not as big of a idea. You can see though, Dr. Quintel, like he wants to expand and explain a little bit more, just like Stephanie Murphy got to explain her butt off, give her all her little editorializations and characterizations of Ashley. But the doctor here is talking about, yeah, this is what she told me. It's what we, like she discussed some of the events that made her afraid. So now the judge is going to give a verbal spanking because of this particular moment.
About Doug, there was prior acts of violence, shooting a gun. No.
Sustained.
Okay, without? Yeah. Oh, you have no idea. Without?
Why don't you go ahead, excuse me, Deputy, would you please go ahead and take the jury out?
So now that for that particular comment that Mr. Taylor said, you have no idea. So everybody's going to leave the courtroom. He's going to tell him, hey, don't talk to anybody. And now he's going to give him a whooping.
Speaking. Mr. Taylor, is there anything you'd like to share before I begin speaking?
I think I'm about to catch a whooping. I'm not quite sure why, but go ahead.
I believe that you expressed you're a veteran of over 400 jury trials.
Yes, sir.
This is all rhetorical. You can feel free to answer or not answer. My assumption is that you're familiar with trial process and procedure, that you're familiar with, as you had mentioned earlier, the rules of professional conduct and decorum. I'm also sure that you realize that if this court makes rulings that you disagree with, whether it's a passing disagreement or a fundamental disagreement with a ruling, I would imagine you're aware of the fact that if ultimately your client is convicted, either you or another attorney or a public defender, if she's indigent, will have every right to appeal to the Second District Court of Appeal every decision I've made from the minute I sat down in this division and started making decisions in this case, all the way through the end of the case. I also would imagine that I'm not the first judge that has made rulings that you disagree with. I would imagine I'm not the first judge that you have looked at up here and said, where in the world did he or she get that from? I would hope that you have not engaged in the conduct like you just did. It was inappropriate. It was unprofessional. We're going to take just a few minutes break. I have this position and I understand criticism. And I expect that. I have often said that I think my job early on as a youth sports referee and umpire prepared me well for the criticism that comes with the job.
Anybody else feel like this is like a monologue or like an audition for something? Like sometimes I feel like when we watch these like trials, I'm like, is this real life? Like, are we like, is this part of a movie that like I'm watching or TV? I have no idea. Like, this is, I just feel like this. I don't know. What do you guys think? Do you think that was directed towards the judge and the rulings? I think it was more out of just Mr. Taylor being frustrated. I mean, yeah, maybe by the judge's rulings on certain things and not allowing certain questions being asked where it was like, yeah, but you totally allowed Stephanie Murphy for like the first half of her testimony to just blab about whatever she wanted to. So why not? Why not for this witness? Why not for this witness? Because it doesn't support the state's case. That's why. So, but now he's going on about like my days as a youth pastor coaching like baseball or whatever he talks about. And I'm just like, okay. But it is kind of funny, this whole little interaction.
However, those sorts of side comments are just, they're not appropriate. And I would caution you, sir, not to do that again. That's extrajudicial matters that have nothing to do with the case or the consideration of the jury. All right, so we'll take a 5-minute break and we'll be back.
Notice how he doesn't even like say sorry or anything. But like comparing that to Bev's verbal spankings to Alan Jackson and David Gennady for saying, of course, so many times. And then Alan Jackson saying like the mic drop moment of shame on you to Trooper Proctor. And she was like, come on, Mr. Jackson, jurors disregard that. Like, you know better. Like, imagine if she did this. Like, if she like closed down the courtroom and was like, yo, jury out. Like, you get up here. Like, this is my house. Like that. I mean, that was kind of badass. Like, he is like, I am reminding you whose house you are in. Like, he definitely owns the courtroom. Whereas like Bev would have just been like, yeah, okay, whatever. But now we're gonna finish up with this testimony. They take a break, and then we'll wrap things up.
Anybody want to follow up questions about that? All right, everybody says no. Let's bring in the jury. Anybody want to follow up questions?
He said that he knew I couldn't talk, but here's a card. I said I don't want that.
Okay.
Yeah.
All right. Did that person?
Oh yeah, there was a reporter too who would, and I wonder. So there is something that actually comes into play, I think, at the beginning of day 3, which we'll recap in tomorrow's video, where a reporter. Well, actually, no, we did get into this a little bit in yesterday's video. What am I talking about? About a reporter approaching Eva Benefield. So I wonder if it's the same reporter that approached this witness, and this witness was like, "No, I don't want your card. I don't need it."
Ask
It was just a nice light moment.
He said that he knew I couldn't talk, but here's a card. I said I don't want that.
Okay. All right. Anybody want to follow up questions about that? All right. Everybody says no. Let's bring in the jury.
It's just nice too to see, like, from time to time you'll see like Ashley kind of smile or laugh. And I know I said this yesterday when she when John Sant came onto, I almost said stage, came onto the witness stand. She had kind of a very similar, like, just very genuine smile. For everybody who's like, oh, she's totally faking it. Like she's an actress. I'm like, even like the best actors, and somebody else like brought up a good point. Like, even the best actors usually use fake tears, like, because they don't. There's honestly, and I could never do this when I used to act. I could never like cry on demand. It really took a lot of just trying to totally go method, which is like messed up, and it really messes with your head to get me to that point, and almost like traumatizing myself to get myself to cry on demand. So it really takes a lot for somebody to simulate real emotion and tears. Again, speaking as somebody who is an SA survivor, and also somebody who used to act and perform semi-professionally. And I know for me, it took a whole lot to get there. Like, I could probably count on my hand how many times I was able to actually cry on cue. And that was only without, like, mentally, like, traumatizing myself to get me to that point, which is, like, really messed up. So it's not very common. Like, a lot of actors need to use, like, the fake, I forget what they're called, like, some kinda, like, droplets, not like a saline, but it's something to just, like, get your eyes watering. It's used all the time because, again, you're shooting, you're filming all day and, um, doing scene after scene. Like, it's not easy. It's not easy. And we saw the Amber Heard Depp trial and what crocodile tears look like, so, again, it's just nice to see, like, little moments like this where we see Ashley kinda smile and just give, like, a genuine reaction, even though this is, like, I mean, I can't imagine being on trial for murder, let alone having a child, like a baby. Not a baby, I think she's 6 now, but a young kid.
All right, y'all can have a seat. Welcome back, everybody. Anybody begin deliberations, talk or communicate with anyone outside the jury about anything we talked about, or do any research? Everybody says no. All right, Mr. Taylor, you may resume your cross-examination.
Thank you. Doctor, did you, as a result of meeting with the two of them together and separately, did you reach any conclusions about the relationship?
Objection, relevance.
All right, you can approach.
So they're already approaching.
Did you make any inquiry, doctor, about why Doug Benefield would want to stay in this relationship?
Objection, hearsay.
Good question.
You can answer.
Can you repeat the question, please? Thank you.
Was there
Yeah,
any observation by you in response to why Doug Benefield would want to remain in this relationship with Ashley Benefield?
I questioned why both would want to stay in the relationship, but specifically to answer the question with Doug, I did bring that up in a session, that it seems like Ashley is saying very disparaging comments, and I'm not sure why and what you see in that ongoingly moving forward. I did bring that up to him.
In fact, you were perplexed by it, were you not?
I was confused, sure. It did, yeah.
Seems like everybody was.
Would it be a fair conclusion to say that he was hell-bent on staying with her?
I would say that he really wanted the relationship to work from everything that he told me.
Okay. We're going to have to recall you, so I'm done.
Redirect. All right, sir. So at this point, you are going to remain under subpoena.
Okay.
You're free to go now, but one or both of the parties may actually call you back later. So all those instructions I gave you earlier still apply. Don't discuss your testimony with anyone, even the attorneys, any other witnesses. You can't watch anything that might be online.
I really like this witness. He's just, like, very energetic, a really interesting guy. You can tell, like, he's totally credible and wants to be able to give an accurate depiction of how he interpreted his time with Doug and Ashley. And mind you, again, this is in just, I believe he said on the 25th that they met, just days leading up to um, Douglas Benefield's death. So really wild. I know this was a super long one, but I think it was really important to get into all the different testimony that we did. And that wasn't even all the testimony. There were like two or three other witnesses that we skipped over. Some of the testimony we cut in half, just again, because it's so much. But I think it really helps paint the picture of, again, where the state is going, where the defense is going, and whose case, and based on the evidence that's been entered into the trial, is supporting whose case. And at this point, I feel like it's kind of supporting the defense's case, even where the state feels like, I guess they're winning in some sense. So let me know what you guys think in the comments section below. At this point, do you think the state is proving a really strong case? Do you think that they are doing a good job of proving some sort of intent and motive, specifically with, well, not that they have to prove motive, but that they are proving some sort of intent, that Ashley intended to unalive Douglas Benefield? on the 27th. Do you think that it was, I guess, in a way, kind of premeditated, that it was something that she was preparing for, something that she was gearing up to do? Or do you think that it was just something that happened out of the moment for fear of her own life, and that it is possible, based on Douglas Benefield's background, his history with DV, in his other relationships, his other violent behaviors and outbursts? Do you think that supports the defense's case, or do you think two things can be true at the same time? Do you think that Douglas Benefield could be kind of a piece of human waste, but also in that moment wasn't necessarily posing a threat towards Ashley Benefield, and she had just had enough, and it didn't matter, threat or no threat, she was going to take matters into her own hands as the state continues to stay. At this point, I will say, I think that Ashley actually was in fear for her life. I think that she was trying to do everything that she could to get away from Doug, and wherever she went, he followed. Which is interesting too, because a couple of people brought up the question of, because Eva Benefield was only like 15 when all of this stuff was going on. So where was Doug? Where was Eva when Doug was doing all these crazy things? When he was doing, I guess, making court appearances in Florida? Was he still living in South Carolina? Was Eva going with him? Was she staying there? Who knows? Because remember, his previous wife died 9 months before he met Ashley, so there was no parental figure in Eva's life at that time for her, I guess, to stay with. I mean, maybe she could have stayed with family, but it's just really interesting, this case. The deeper and deeper we get into it, and it's only getting crazier from here. Like I said, day 4 was absolutely wild. When we get up to it, we have some catching up to do still, but hopefully we'll be back on track by Monday. So I'm gonna work to get another video out to you guys tomorrow recapping day 3, and then on Monday we'll do day 4, and who knows, we'll probably be on verdict watch early next week. I would say probably between Tuesday and Wednesday. So we'll see. We'll see. Or if this thing drags out a little bit longer, but things have been moving at a lightning pace. And I don't know if that's good or bad. If the state should have maybe called a few more witnesses, experts. I don't know. It's really hard to say because it's not a who done it. We know who did it. She admitted she did it. It's just a matter of proving intent. And that is going to be the burden that the prosecution carries on until the very end. So with all that being said, if you enjoyed today's video and this case is as fascinating to you as it is to me, make sure you hit that subscribe button. Make sure you hit the notification bell. You hit the all on it. Soon I'm going to get like an editor to do all the crazy graphics to point you to things. But I just don't have that time or skill set at this moment in time. But we are getting there with the growth of this channel. But make sure you hit all so you get all of the notifications from me as soon as I post another video, so you never miss another update from me on this case and every other case that we are currently covering, including the Karen Reed case, which seems every single day something comes out in regards to that. So as more news and information comes in, I will be posting about it. But most importantly, make sure you hit that like button, because that tells the YouTube algorithm that yes, this is worthy news and that these stories are important. And I think they are, because especially with like YouTube censorship and like the words that they don't like us using on YouTube, they don't like us saying DV, not DV, but what DV stands for. And that's just really upsetting to me, because it is a topic that we need to talk about and not pander around. And we need to be forthright and be able to talk about it openly and use these words and call it what it is. So it makes making these videos sometimes a little extra challenging, but I appreciate you bearing with me. So tomorrow, like I said, will be the day 3 recap. We're going to get into a lot of testimony. I actually haven't even sifted all the way through, so a lot of it will be kind of a real-time reaction. But I did tune in for all of day 4, and that is going to be wild. I'll probably even make a separate video of Ashley's testimony on the stand, to be honest, because it was a long one and it deserves its own video. So anyways, I will see you in the next one, and I hope you guys have an amazing weekend ahead of you. All right, cheers.